When is the returnable date?
There are different dates, my lord. Some are, most have expired, my lords. 7th October, 30th September, 7th October. My lords, all different dates. 5, all have expired. I have annexed the orders as well.
Whether it will be appeared in the to-be mentioned?
Yes, my lords, that would be nice, my lords, because order cannot be passed without affidavits. So at least a direction can be given to the state. Much great for them.
With your lordship permission, I would like to mention two matters. One matter is in a motion stage. It was last heard on 22nd September, and direction was given to list this matter before the next available circuit. Inclusion in the list. Your lordship, one more matter is that we have filed a CAN application for restoration. CAN 2 has been filed in this matter. Kindly, we have filed on 27th.
I guess the dismiss for default.
It was dismissed for default. We have filed for restoration.
My lord,
3 NECC matters, my lord. All matters are here.
What is the status now?
For the hearing of the paper books are all ready.
Everything is ready. File it.
my lord,
We have been permitted to mention 2 matters, my lord, motion matters for inclusion in the list.
Which matter?
Motions.
Motion.
my lord, may I be permitted to mention a writ application pertaining to Group 2? My lord, this is in the motion stage. On the last occasion, the School Service Commission had sought for accommodation to get some instruction, my lord. But till date, it was not listed, my lord. If it could be fixed on Thursday.
Is there any date fixed in that matter?
No, my lord, they had sought for an adjournment simpliciter seeking instructions, and next circuit it was fixed, my lord. This is the circuit.
So inform the other side.
I have mentioned upon notice, my lord. I have given notice to the other side, my lord. Today
Where
also,
is the notice?
my lord, it is, I don't have a, I can give it in 5 minutes, my lord.
File it.
With my mentioning slip, I'll give it, my lord. Grateful, my lord. My lord, if it could be fixed on Thursday.
Daily course is standard heading to be mentioned, serial number.
In this matter, some clarification is required.
Yes, my lord, I am ready to give the clarity.
Because without clarification, disposal is.
That
not
was
good.
required, my lord. That's why I am hesitating on the last occasion also.
There is a submission from the side of state that they are not utilizing the land. That is the main clarification I require.
My lord, I think all the confusion
Because in
should
your petition, you have alleged that the boundary wall has been made
in and over the property of the petitioner.
Yes.
And that has been admitted by the police respondent earlier on 2 occasions. That's why the 2 separate direction has been given to the police authorities. Number 1, to measure the land by appointing one concerned authority, that is the revenue inspector. And he did the inspection in presence of all the parties concerned. Thereafter, report has been filed to the department as well as it has been communicated to the court also. Thereafter, at that juncture, it was not the proposal from the side of the petitioner.
On the other side.
Mr. Borman, I informed him yesterday at night. I saw that the matter is listed on motion. So he told me that I didn't mention anything. Then maybe it is the clarification.
This is the instance of this court. This matter.
Actually, I think the state right now, the submission of the state is communicated.
Orally, that should be in written form.
That should be written from as because it is settled that the property has already been illegally trespassed and taken by the police authority. See, all the confusion.
Your submission is different.
Yes, I am helping to the court. Please see, this has already been annexed with my application.
So
Your
I
Honor.
pass this over this matter, inform the other side.
Okay, my lord, no problem. It's okay. I'm waiting.
I am persevering for.
I'm waiting. No problem. It's okay.
Inform. So in presence of both sides, clarification is required.
Already it is there. This document itself, I have already annexed this document with my application.
But in application, I
It is-
did
it is
not
clear.
find
I don't
anywhere
know why
that the land has been demarcated and separated.
And they intend to purchase the property by this report, internal report,
That is the internal department.
department report, and I have been made a copy.
Here question is only I require whether your land has been bounded by them
Yes,
and
my
they are
lord.
utilizing.
With taking all responsibility on behalf of my client, I am submitting again, my land has been illegally taken
And
by the
crossed
concerned authority. And the boundary wall has already been done.
That is, the-
Yesterday, his submission was quite different. Yesterday, regarding, there were, I think, 4 or 5 matters pertaining to the.
and that is another matter. This is another. No, this is another matter. Actually, there was some submission from this.
কেন না জেনে কেন কোর্টে এরকম করে সাবমিট করে দেয়, ইটস ভেরি ডিফিকাল্ট।
Sorry,
very difficult.
please. Let him understand there are similar matter type,
Yesterday, there were similar matters.
but this is not the similar with that. That is different matter. I am passing it over.
My lord,
For the time being, you
my lord,
inform.
my lord, my lord.
Because there is a written instruction should be in
I am
the,
satisfying the court that already land has been taken by the police authority and they intended to purchase the property. They persuaded the matter to the government for taking the fund also. In that document, it is written there.
I did not find, okay, I will pass it over. Next matter. You inform other, the learned advocate.
yes, yes, my lord.
Here, yes.
My lord, my lord, my lord. না 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 কিছু না অলরেডি অ্যানেক্সার আছে, আমি টাইপ করে দিয়েছি। ইয়েস মাই লর্ড। This is one pension matter, my lord. করবে তো?
Actually, short passover, is DSC not come, short passover.
শর্ট অফ আজকে করবে তো?
Short pass over.
পেনশন ম্যাটার আছে।
Next.
Please, my lords, I beg to appear for the petitioner, my lords, in serial number 4. My lords, there's a small difficulty, my lords. The service is not complete, my lords, and I'm seeking for some time, my lords, so that I can complete service upon all respondents. My lords, it's a short matter regarding non-consideration of a representation. My lords, only difficulty is, my lords, I have not filed an affidavit of service, my lords.
There are private respondents also.
Yes, my lords. Therefore, my lords, I'm requesting for some time so that I can complete service and come to your lordship, my lords.
So next week,
My lords, next circuit, because I'm traveling next week, my lords, there's some personal difficulty.
learned advocate appearing on behalf of the petitioner on virtual mode submits. The affidavit of service has not yet been completed. Accordingly, he seeks accommodation. Let the matter next available bench.
I'm grateful, my lords, deeply grateful.
आपके पूजा होने तो अगर mention कीजिए।
Grateful, my lords.
Plan for the state property.
Ram for the Kujbihar municipality, respondent number 2 and 3.
I am from the respondent number 4.
Who is the petitioner?
Mr. Hilal Shah Poddar, he is appealing for the petitioner. ma'am.
Yesterday petitioner sought adjournment.
Yes, my lord.
Hilol Saha Poddar, he is the advocate here.
He is appearing for the petitioner.
He is the advocate practicing in this.
Here, Lordship, here.
Okay, pass over.
My lord, in that case. No, my lord. My lord, my lord.
Pass over him if he come.
My lord, in that case, kindly Lordship, make it 2 p.m. because my lord, I have some engagement before court number
Okay, pass over matter at 2 p.m.
2 p.m. Lordship. Wait for your Lordship.
My lord, I am appearing for the petition in item number 6, my lord. My lord, my affidavit of service is complete, but I have come to learn from the learned respondent representing for the CGST that they have not received the copy yet, physical copy yet. My lord, would kindly give me 1 day's time to serve them a physical copy since they received the copy in physical form. My lord, my affidavit of service is ready and my clerk is there in the court. My lord, he will hand you over the affidavit of service, my lord, if my lord allows.
We will file the affidavit of service before this court.
My lord, the affidavit of service is ready. This matter has been taken up for the first time, my lord. I have to put the affidavit of service in record.
Who will file the affidavit of service?
My lord, my clerk is there. My lord, he will hand over the
Again,
copy of the affidavit of service.
at least your junior should be here to file
My
the.
lord, I tender my apologies, my lord. My lord, kindly give me tomorrow's time. My lord, I will appear physically and hand over this affidavit of service. My lord will kindly give a.
On the prayer of learned hearing on behalf of the petitioner on virtual submits. Now seek for adjournment. For the day.
Grateful, my lord.
Yes, my lord.
Your Lordship, I appear through the virtual mode, Your Lordship, in this matter. It's a Group 4 matter, revenue matter. Your Lordship, I have filed a writ petition against an order in appeal passed by the Senior Joint Commissioner of Revenue, Your Lordship. I do not have an alternate remedy, Your Lordship. The reason why, because Your Lordship, this order has been passed by the First Appellate Authority. The appeal against this order lies before the GST Tribunal, Your Lordship. The tribunal is yet to be constituted. Therefore, Your Lordship, my only remedy under law will be under Article 226, for which I have approached this court. Your Lordship, if I may briefly.
There is no tribunal in this area?
Your Lordship, the tribunal has not been constituted under the Act.
Okay.
Your Lordship,
The other side.
Yes, lordship. This is a affidavit of service. Third October I served.
Nobody is there to represent the GST. GST authority. Are you appearing? So if suppose GST council will not be appointed.
You have assured me that in the next week, they are changing somebody. I think there are 4 similar matters. It's 11, 10, 8 and 7. 7, 8, 10, 11, isn't it?
Yes.
Similar.
Why you are not appearing in this matter? You take instruction
I think instruction.
for the time being. Because there are so many matters pending.
Yes, boss.
Similar matters are pending. So without appointment of the learned advocate from the side of,
The competent council who was looking after the matter here resigned, that's the whole problem.
it is not the solution.
Solution is that I have contacted the legal members.
Because immediately asked your department to appoint.
Yes, madam.
Otherwise, matter will be a hard ex parte.
And this morning I had talked with them. They are.
In spite of service, no money.
Next week, they are sending down.
There are no other advocates here who can represent.
They are doing matters. Only we are four councils, I am taking the responsibility of the provide. So I am having my head to my operating school. Then the panel of councils. I will just. Especially the otherwise, other matters, some of them.
So I am fixing this matter on Wednesday. Are you in
Your Lordship,
to engage somebody or you represent?
Your Lordship, if I may kindly request, Your Lordship, next Wednesday, Your Lordship, if it can be on Monday or a Tuesday, Your Lordship, next week. If
Thursday,
that is possible, Your Lordship, Monday or a Tuesday. Your Lordship, actually Wednesday, Thursday, I'll be actually traveling to another city, Your Lordship. That's the only issue, Your Lordship. If it can be done on Tuesday also, Your Lordship.
I will be reaching on Monday. My council from Thursday. So the relatives from the, they have time to get an instruction and get preparation. It is convenient for us, my lord, on the
16th on Monday, next Monday, 16th.
at least on Tuesday.
Then 2 days or 3 days will be left.
Because he is not arriving this week. He will come next week on Monday.
Okay, 17th I am fixing the matter, 17th.
Much obliged, Your Lordship. Much obliged.
Affidavit of is filed by the petitioner is taken on record.
19.
Submits that no council has been appointed by the department. And it will take at least 1 week time to engage someone to represent the respondents. He seeks adjournment on that ground. Let the matter be listed on 17th.
Your Lordship, 7, 8, 10 and 11 are all similar matters, Your Lordship. It's just different financial years.
You asked your junior when the matter 7, 8 and
10 and 11.
okay, 7 and 8 similar order.
10 and 11.
10 and 11.
Same order.
10.
Yes, Your Lordship. They are just different financial years, Your Lordship. Issue is same.
You submit your affidavit of service.
Serial number 8.
Same order.
Much obliged, Your Lordship.
Lords, this is also GST matter, my lords. Service of affidavit has already been filed, my lords.
So this matter
Yesterday.
will also taken up on 17th. 18th. 18th.
Yes, grateful, my lords.
Similar order. You filed the affidavit of service?
It's filed, my lords. In the first day, it was filed by my junior, my lords.
Same order.
Your Lordship, 10 and 11 are similar to 7 and 8, Your Lordship.
Yes, yes,
Much obliged, Your Lordship.
same order.
Good.
I'm happy for respondent 456.
I think.
Every matter, everyone is seeking short passover. Why?
I apologize. He's in another court, that's why. Oh.
Actually, I was trying to mention one matter in the principal bench. Lord, the petitioners before your lordships, Lord, they are not aspirant to not become doctors. Lord, I tell you, lordships, Lord, we have all qualified in the grade class 12 exam. Then we participated in the joint entrance exam. But we have some ranking of the petitioners. Now what happens here, let me first explain it to you, lordship. This is not the first time that we are moving matters. I have annexed several orders of this honorable court, passed from the circuit bench, from the principal bench. It first started from one order passed by Justice Sanjeev Banerjee, then Justice Dipankar Dotto.
Similar matter or this matter?
Similar matter, not in this matter, similar matter. But what happens is today, as on days, the situation is that we all qualified in the joint entrance examination. Now my ranking is 100. At the counseling and in the mop-up round, I don't get a chance. But after the mop-up round, there are, as on date, 250 seats are vacant. 250 seats are vacant in the state. These seats will go vacant forever. These are all seats, valuable seats for doctors. Now, under this situation, we approach you, we make representation to there are seats vacant in
your ranking.
I'll show you, lordship. Not first, your lordship, can you take page 34? Take page 34 first.
Yes, 34.
Now, this is the ranking of the petitioner number 1. Now, Alok Rajput, his rank is, kindly sees
20056.
No. His rank is not 200. Kindly see, after the first box, in the middle, total marks obtained out of 725, 76. Malaras kindly got it? Page 34.
Yes, 34. P3.
3. After the first box, immediately after, just below the.
That is scored obtained.
No, just below Indian. Just below Indian, after the first box, nationality Indian, after that. Below that. Malaras kindly got it? Total marks obtained out of 725, 76.
Yes, 576.
Yes. Then kindly see the box. NEET All India rank 44537. Category OBC NCL. Then category rank is 220056.
Yes.
Malaras kindly got it? Now this goes on up to page 39. There are 6 petitioners. So all the petitioners' rank are there up to page 39.
43 or
Hello?
up to
page 39.
39.
Yes. 35 is petitioner number 2, 33 is petitioner number 3, 34 is petitioner number 4, 7.
There are six
petitioners. 6. So all of them have qualified the joint entrance exam. Now then, why are we before your lordships? Well, let me first explain things to your lordships, Lord. But kindly not take one order of your lordships court passed by Justice Joy Singh Gupta, or not. I have annexed several orders. Let us start from one by one so that I can show that this is not the first time. Kindly come to page 51.
Yes.
But this is one order passed in 16 July 2019. Kindly have a look at it.
Yes.
The petitioner is a qualified doctor, but this is from MBBS to MD. This is from MBBS to MD. I'm just showing it. The petitioner is a qualified doctor and has passed Bachelor of Medicine and Bachelor of Surgery courses from the KPC Medical College in the year 16. Thereafter, the petitioner participated in the eligibility and entrance test PG 2019. Subsequently, the petitioner was only able to participate in the second round of counseling. The grievance of the petitioner in this petition is that she has not been allotted any seat in the MD radiology course under NRI quota. The petitioner had come to learn from a notice dated 30th May 2019 that certain seats were lying vacant in various medical college for postgraduate studies. Pursuant thereto, petitioner has also made a representation for admission in the MD radiology course. In this background, the petitioner contends that notwithstanding the representation, the respondent authorities have taken no steps in the matter and have deliberately kept the matter in abeyance. Now, kindly pause here for a moment. Instead of PG, kindly read here MBBS, same representation, everything is same. I will show you orders with regard to MBBS also. The petitioner relies on several orders passed by the Honorable Court in ASTA number so and so, University of Pawan Mandal. This is the judgment of Justice Sanjeev Banerjee, then Arnab Karmakar, Karar, then Rituraj Miyogi, then Lord Kaushik Sarkar, Pujan Health University. It appears, this is very important, it appears from the aforesaid decision that there is a consistent line of authorities whereby the university and the respective college have been directed to admit individuals provisionally in a college to be selected by the university. Court records is a consistent view. I am of the view that the petitioner in the instant case stands on the same footing as the petitioners in the aforesaid writ petitions. I find that the petitioners have a strong prima facie case. Since the process of admission having been already initiated, the balance of convenience is also in favor of orders being passed as prayed for by the petitioner. In the circumstances, I direct the university and the registrar, being respondent number 1 and 2 respectively, to admit the writ petitioners provisionally in a college selected by the university. It is, however, made clear that the provisional admission in favor of the petitioner will be subject to final result of the writ petition. This order will not create any equity. Then the factions are responding directly to file affidavit. But kindly take the next order. Page 54, 3 petitions were decided. I had the occasion to appear. Now kindly see at the top, page 54. This is at the circuit bench at Jalpaiguri. Malaras kindly got it, more?
Yes.
Justice GUPTA delivered a detailed judgment. This is the judgment. Kindly allow me to place it. These are the applications praying for directions upon the respondent authorities to grant admission to the petitioners in any of the undisclosed vacant seats in MBBS course 2021.
You are also MBBS course.
Yes. I just showed not first MD, then MBBS to show that it is not the first time I am coming. This is the consistent view of single bench, division bench. I will show you orders up to Supreme Court. In one of the college under the respondent authorities and allow them to attend classes with the students of 2021 academic year. Also to grant registration number to the petitioners, since the applications involved in the same questions of law and similar facts and same are taken up for hearing together. Learned Counsel appearing, I appeared in this matter on behalf of the petitioner in the application submitted as follows. Every year, several seats fall vacant after students take admission.
Entire order.
No, just to show that what is the fact today, that was the fact there also. Just to show that. Now, my lord may consider that this is my submission, what is recorded by Justice Gupta. Same, similar.
The operating portion.
Yes, kindly come to the operating part. Lord, should I show your lordship that the court considered the earlier orders passed by this court? But kindly just allow me to place paragraph 2, then I'll take it to the other portion. Counsel appearing for the petitioner applicant submits as follows. Every year, several seats fall vacant after students take admission in the medical college under the respondent university. Present petitioners have scored good marks in the national eligibility test. They successfully qualified the secured respective marks and were allotted all India ranks. The petitioners participated in all-round counseling conducted by the respondent university authorities in different phases. They are also involved in the mop-up round of counseling. It is submitted. It is a submission of the petitioners that they are much better in rank than the candidates who got admitted in the counseling process. Only if this court allows the petitioners to be provisionally admitted in the courts, in the event any seat is found to have fallen vacant, the said seat will be protected. Otherwise, if any of the selected candidates opt for any other college or university and his or seat consequently falls vacant means same cannot be filled up subsequently. The problem lies with the notifying of the vacancies. The provisional admission would essentially mean that in the event more meritorious eligible candidate comes up before the year end, then provisionally admitted candidate has to vacate the seat in his or favor. On this, reliance is placed on a decision of a single bench, WPA number so-and-so, division bench ASTA. Learned counsel appearing on behalf of the respondent authority submitted as follows. Map of counseling for the course is already over. However, some vacancies could be found. It would nevertheless be difficult to accommodate the all petitioners. I have heard the submissions. In West Bengal, held in the signed by the Pawan Mandal, it was contended on behalf of the respondents that in view of the orders passed by the Honorable Apex Court in Swansea petition number, in no event can any admission made beyond the cut-off date. In this context, division bench of this court held that such direction would not come in the way of making direction for admission in case of present nature. Honorable Supreme Court might not have intended that a seat which could not be filled up in the by admission before a particular date because of laches of the authorities should never be filled up. The division bench further held that it was more so when the writ petitioner is not at fault and the blame for omission to invite the surrendered vacancy for mop-up round should be borne should not be borne by the appellant despite having information from the writ petitioner, did not take any steps to upload the vacancy in the website. Division bench went to rely on a decision of the Honorable Supreme Court in 2012 7 SCC. In the present case also, the facts are quite similar. And I also say similar, absolute similar. It is because of the non-notifying of the vacant seats that there is chance of seats remaining vacant for the rest of the session. Amongst other things, seats in the medical college remaining vacant. Relying on the decision of the division bench, this court several subsequent decisions were passed, respective single judges of this honorable court, allowing seats found vacant to be provisionally filled up. One may rely on such decision of this honorable Shonak Mandal, so and so. So, Lord, I have shown you lordship all the judgment. Now, we come to para 7. In view of the above, it would be expedient to allow the petitioners to provisionally admitted to the courts in question in the event actual vacant posts are found. However, such provisional admission would be given in terms of the ranks obtained by the candidates say the writ petitioners. But I invite your lordships to pass the similar order. Only one change would be there. Kindly come to the operative part of this order of Justice Joy Sengupta. Justice Sengupta said, in the event there are actual vacant posts to which the petitioners are entitled to be admitted, respondents are directed to provisionally admit the petitioners in the college of their choice within a fortnight from this date. Such admissions will be on a provisional basis, subject to the availability of vacancy for the post. This shall not create any equity in favor of the petitioners. And as between the present petitioner, respective ranks will be determined which present petitioner, if not one, would get a benefit. So, Lord, suppose petitioner number 1 has a better rank, he will get benefit than the petitioner number 6. Only one thing, Lord, as per my information, my learned friends are there on the other side.
Where you have mentioned that 250 seats are lying vacant.
I have made representation. Lord, I have made representation.
How do you have got that information?
Kindly come to the representation at page 40. My representation. Kindly take page 40. Kindly see at the top. I have sent this email on 27 September to the principal, North Bengal Medical College. At the top.
So you want to admit in the North Bengal Medical College?
That is why I am before your lordships. Otherwise,
all are wanted to admit.
Yes. If
and
there are
250 seats are vacant in the
no. 250 seats are vacant in the state, entire state, total university. But suppose
North Bengal, how many seats are vacant?
Let us take a situation that there is one seat vacant. So amongst the petitioners, whoever will have the best rank, he will be admitted. If there are 2 seats vacant, 2 of them, whoever is the best rank will be admitted provisionally as per the order of the court. Lord, the respondents are there to inform your lordship whether seat is vacant or not and which quota it is vacant, because there are state quota, all India quota. I would say all India quota is vacant.
But there are so many other meritorious students are there before your ranking.
That is taken care of. Kindly come to the earlier orders of the Honorable Court. That is taken care of. These questions.
Provisional admission
yes,
will be subject to the
result. Suppose Lord, tomorrow, Lord, Mr. X comes up to your lordships or to any other honorable judge saying that I had a better rank than the petitioner number 1. Because it is provisional, he will get admission. But we kindly appreciate one thing.
The seat should not be vacant line.
That's the concept, that's the ideology with the.
And students should be get opportunity.
Yes, because these are valuable seats. Now I will show one more judgment to you. Let me show you one more judgment.
So what happened about your representation? They have considered?
No.
So where from you have got information that there are 250.
But kindly allow me to place page 40.
40, you have made a representation.
Yes, I so aspiring candidate of MBBS UG. I had registered for the national eligibility come test. I have been allotted roll number so and so. I had appeared in the national eligibility come entrance test so and so. I had qualified in the seat examination, obtained all India rank so and so. I had registered for counseling process held by you after declaration of the result. I had successfully participated in the said counseling process. However, I have failed to obtain admission in any medical college through the counseling process till the second round of counseling. It is pertinent to mention from the reliable source. I have come to know that a few seats in the MBBS course in North Bengal Medical College and Hospital and other medical colleges under your esteemed authorities are remaining vacant. As a meritorious student, I have done all things very well in All India examination, but failed to obtain admission. Therefore, I am requesting you to kindly consider my past educational record, admit me in any of the vacant seat. Otherwise, the seats will unnecessarily wastage due to disregard on the part of your authorities. But I say from the bar that I have information almost 250 seats are vacant. But they are there to inform your lordship whether it's 250 or 150 or one seat. But my representation to the principal North Bengal Medical College that the seats are going vacant in your college, please allow me to take provisional admission. Now, to answer your lordship's query as to what will happen if others comes, kindly Lord, again come back to the order.
Yeah, there is mention if somebody comes.
Yes, he will get precedent to get
admission.
But today, suppose your lordship,
your admission will be gone.
Today, suppose your lordship is not with me, your lordship doesn't pass the order. The seat will go vacant forever. Now that was the concept on which the orders are passed.
Any authority of the Supreme Court?
Lord, kindly take page 61. Kindly take first page, take page 61.
61.
61.
SLP
was dismissed. SLP preferred. Kindly see who preferred the SLP. Page 61.
Medical Counseling Committee.
Medical Council of India preferred SLP. Not against the judgment dated 2nd July 18, AST 16 of 18. AST 16 of 18 konta dekhi. The appeal was preferred in the Supreme Court. The appeal has been dismissed.
Any other submission?
Kindly take one more judgment of justice. Recently, Justice Abhijit Gangopadhyay in the last circuit passed an order. Kindly take page 65. Now the provisional admission which we obtained earlier has been confirmed by his lordship. Kindly come to page 65.
Yes.
There's one more order on page 62. I'm not troubling your lordship. It's the same line. Page 65. Kindly take.
Yes.
Pursuant to the order dated 4th November 2019, Honorable Justice Subrata Talukdar. Kothay gelo Justice Talukdar order ta? Yes. But kindly take page 62 first. 62. I'm so sorry. 62. Malanas, kindly seen it? WPA 680, 4th November 2019. Kindly come to the operative portion at page 64. Page 64.
Yes.
Since the matter has originated in the circuit bench, considering the vacancies contemplated to be in existence in the North Bengal Medical College, as well as in the light of the submissions made by the London Council for the University, other colleges in the university domain, liberty is granted to mention the matter before the next available circuit bench. Period granted to exchange of ordering portion. Let me show you the ordering portion. Yes, page 63. Having heard the parties, considering the materials placed in the records in ad idem with the immediate view taken by the learned coordinate bench as that as a successful NEAT 2019 candidate, the petitioner has accrued a right to study in a medical college against the vacancy which is said to exist. Accordingly, this court permits the petitioner to be provisionally admitted to a vacant seat in the medical college. Page 63, last paragraph.
Yes.
Then Court said you file affidavit. Now the writ petition was taken up finally at page 65. Pursuant to the order of 4th November, I have just shown you by the Honorable Justice Subroto Talukdar, as his lordship then was, I am told by the learned advocate for the West Bengal University of Health Sciences, being the respondent number 2, that the petitioner got admitted in the college and is now pursuing his course, and he is on the 4th year of the studies. I hold that there cannot be any looking back. The university filed one appeal which is kept pending for 3 years, but there is no restraining order. The petitioner's career as a medical student cannot be jeopardized. He is pursuing his course in a medical college. Therefore, the provisional admission taken by the student is now confirmed, and he shall be treated as a student who took admission normally in the said medical college. In the matter, no affidavit of opposition has been filed. Honorable advocate for the university submits that as the appeal has been preferred, no affidavit has been filed. However, such type of matter where the future of a student is involved, this court cannot wait. So the student's future can be kept on tender hooks. Therefore, the writ petition is allowed and the petitioner shall be treated as a regular student. So, I am not only showing your lordships an interim order. Page 62, interim order passed by Justice Subroto Talukdar, 4th November 2019, allowing admission. Page 65, 24th August 2023, Justice Abhijit Gangopadhyay confirms the admission and says that he will be treated as a normal student. Lord, this has been the consistent view of the Honorable Court. So, Lord, I would beseech your lordships that my lord may direct that they will give us admission provisionally in all India as well as state quota, whatever seat is available, subject to what my learned senior friend says.
Fact is that, my lord, counseling is closed at 31st September. After counseling, we come to know the several seats.
When was the cut-off date?
Cut-off date was 31st September, 30 September. After counseling, we come to know the several seats are lying.
30th September counseling over, I filed the writ petition on 29th September before the counseling got over.
On
30th September.
30th September.
And 29th was the filed the writ petition.
and cut-off date was over on
30th. Classes was started from 1st October. Classes was started from 1st October.
cut-off date when you have told? Cut-off date?
Cut-off date is 30th September.
Same.
There is, as such,
Counseling is over.
I am telling my counseling is over, admission is over.
When
We have
admission
no
was over?
authority.
When-
We have no authority.
When admission was over?
30th,
Same day.
same day. This is a fixed, sir, my lord.
My lord, 30th is the last date of counseling
And admission.
on the admission. Lord, it happens like this. Counseling is conducted by the authorities. They send it to the college on those days. That same days.
We have no option
30th
to
was the last.
further counseling. As such, several seats are lying vacant. In every year, students come, by the order of the court, several students was admitted. It is a fact, man.
But the student should get a chance. Why vacant?
Yes.
Who will give the chance, madam? Without the order of the court, how can you admit them?
Every year, if the medical seats lying vacant,
How
what is the
how
use?
can I admit?
What is the use?
How can I admit, my lord?
An entire state is a
Cut out
lack of
30th.
doctors.
Lack of doctors.
We cannot admit anybody after 30th without the order of the High Court's order.
Lord, if your lord directs, they cannot.
Yes, my lord. If you are direct,
So there are several judgments of the
Yeah,
High
several
Court as well as
and
Supreme Court also.
whatever he tells, everything is correct, my lord. Only one thing, the
Provisional.
the marriage should be guided.
So writ
Whatever
petition
the-
should be disposed of.
Yes, kindly pass the order, my lord, and dispose of, kindly direct them to give me provisional admission on the basis of the
All
merit.
India quota and state quota, my lord.
Lord, may I say this to your lordship, my lord? My lord may come to Justice Joy Sen Gupta's order.
You are
I-
state quota. You
Lord,
are-
kindly mention
State quota, my lord.
All Indian state.
Come in the prayer.
It's in the prayer also. Kindly come to the prayer portion. Kindly take the prayer portion. Page 12.
Yes.
mandamus do issue directing the respondent authority to grant admission to the petitioner in any of the undisclosed vacant seats in the state quota, all India quota in the MBBS course 2023. Well, now if my lord comes to Justice Joyce Gupta's order, I'll come to Justice Joyce Gupta's order once, page 58.
Yes.
But subject to correction, paragraph 8, subject to correction by Lord Sisma, my lord may pass the same order, only mention that in all India quota as well as state quota, wherever the vacancy is available.
Yes, my lord. All India quota and state quota.
There will no confusion.
Within the university.
Similar judgment.
It's 58. Because 58 is the operative portion paragraph because Justice Sengupta is very, not kindly say I'm reading it. In the event there are actual vacant posts to which petitioners are entitled to be admitted, respondent is directed to provisionally admit the petitioner in the college of their choice within a fortnight from date. Then kindly says such admission will be on a provisional basis subject to availability of vacancy for the post. This shall not create any equity in favor of the petitioners. In the event then D, as between the present petitioner, their respective ranks will be determined. Which of present petitioners, if not all, would get benefit of the such admission. As Mr. Maiti has said, Lord, that merit. Suppose petitioner number 1 has a better rank. I should be candidate, Lord. I am representing all of them. Petitioner number 2 is better than 3. So if there are say 2 seats vacant, on the merit between them, they should be given priority. But here only one thing has to be mentioned. Instead of post, it should be seat, vacant seat, because this is not a Lord substantive appointment for a job. It should be seat and Lord seats in all India as well as state quota. Only that has to be written. If I invite your lordship to paragraph 8, in the event there are actual vacant post, vacant seats lying in the all India as well as state quota. Only mention this and not dispose of the writ petition.
Class is started, my lord, from 1st October.
So we'll take immediate admission.
That should be taken care of.
Okay, is there any other submissions?
No, my lord, I have nothing.
Okay, I'll pass order.
Fine.
Next is
Reserve.
next item is same.
Appearance, please. Serial number 12.
12 হলো তো এটা কই দিচ্ছ তো
Point number 2 and 3, my lord.
13 is same.
Same.
How many candidates are there?
4.
Same MBBS. All are for MBBS.
Same, my lord.
That is why I time and again mention that merit, whoever is better, he will get admission.
And suppose somebody else come later then?
If he is better, Justice Sengupta has cleared it that he will get admission.
My lord, with direct respond number 2 and 3, my lord.
2 and 3.
With the admission authority.
2 and 3, all India and state quota. Only mention this one.
This is the affidavit of service for item number 30. Evidence required.
But I am here till 4:30. My lord requires any kind of assistance. I am here, my lord. While passing the order, my lord feels, my lord, I'll be at your lordship's disposal.
Okay.
And my lord, I must congratulate your lordship's, my lord.
You have filed the affidavit of service?
Yes, yes.
Yeah, what
For
लिखे
that-
रहे हो ना? Affidavit of service filed on behalf of the acclaimed, taken on record, heard both sides.
Lord, grateful to your lordship. 13 তো 13 ডালবেন 13 তো
Same.
না ও তো একই
Similar. Affidavit of service has been filed for item number 30.
In this matter, you have not filed any, you have
But-
not filed any, same,
My lord.
Item number
same vacancy.
Same application.
और my lord may pass one order mentioning 2 writ petition numbers. Like Justice Sengupta dealt with 3 writ petitions together.
Okay.
Serial number 14.
Grateful, Lordship.
Okay. 15. Item number 15, stand for pass over.
Yes.
Your Lordship, in item number 16, Your Lordship, in item number 16, Your Lordship,
Yes.
69 for the petition, Your Lordship. Your Lordship, my learned friend over there has the affidavit of service, by the learned advocate on record, but the service upon the private respondents, there are 3 private respondents.
Not there. Your friends is not there.
Your Lordship, the thing is, my instructions is the service upon the private respondents, Your Lordship. There are 3 private respondents. Respondents number 8, 9, and 10. It is not complete, Your Lordship. 8, 9, and 10. This is regarding an illegal construction, Your Lordship, by the private respondents. They have done so in PWD land belonging to the PWD department.
So you required some time.
Yes, Your Lordship, if it going to be taken up in the next circuit bench.
Okay, learned advocate appearing on behalf of the appellant on virtual move submits. The service could not be affected on the private respondents.
Yes, Your Lordship.
Accordingly, he seeks sometimes to he had seek adjournment.
Lordship, one submission may be added on behalf of the state that the land on which the alleged construction, illegal construction is going on belongs to Jalpaiguri Jila Parishad, not PWD.
Maybe let them serve and they will come and thereafter, because private respondents are there, they should have given opportunity to hear it.
I am for respondent number 3, my lord, the municipality, my lord. Let my appearance be recorded.
Yes. Your appearance may be given also. What are near the appearance? Next.
Affidavit, sir.
Item number 1, both advocates are here. We call the passover matter item number 1.
I am not for.
Item number 1, you are appearing, no? State. One clarification is only required. There is one allegation in the writ petition that the respondent number 3 has raised boundary wall on the land belonging to him in accordance with the provision of Siliguri Municipal Corporation. Yesterday it was submitted that demarcation was made, segregation was also made, but the land was under the occupation of the respondent.
The portion of the land, the construction as per the allegation that has been made on the recorded land of the commissionerate. There is another case. In another case,
that should be in written form. Then only this matter can be adjudicated. Either I can send this
yes, that can be said for because another case,
representation before the respondent to consider again and again
that we have submitted yesterday.
Because the matter is pending since 2013. 2 writ petition already filed.
This is the 3rd time.
So I think it will be better to take some short report. If the land is demarcated, segregated, and hand over to the
long back in 2016, Lord.
Then there is no merit.
Lordship.
If the land is with the respondent, then there is a merit in this case.
One thing. This document is already annexed page number coming to the
Page number?
Page number
38. Oh, that is illegible actually.
That's why I made it in typing.
Okay.
See the report. This is not my report. This is the letter sent by the Commissioner of Police Siliguri Municipal Corporation on 18/7/2016 after the demarcation, addressing to the district magistrate. See, in reference of the writ petition number such and such, this is to inform you that a piece of land recorded under jail number such and such, that is the land in question over here. A survey has already been conducted over the land by the surveyor team at the block and LRO office Matigara and the report has been communicated accordingly to your good of age. Earlier, white such and such memo number saying authority copy enclosed here for readiness. In this respect, it's to inform, mention here that the owner of the proposed land submitted a petition which has been received in this office on 24/6/2016, in which he stated that he is ready to accept any proposal given by the part of the government in respect of the proposal land. Copy of petition submitted by the landowner is enclosed here. Hence, in view of the above matter, may kindly be moved to the government with a view to registration the proposed land in favor of the police department.
So what is your petition?
Petition that is annexed with that with this.
Either you have given some consent.
Yes.
Where is that petition?
See,
Have you annexed? Have you annexed in this?
Yes, my lord. That is the one of the representation coming to the page number 41. That is received by the concerned department.
41 is order of communication order.
This is the communication of the order.
Communication of order.
What is your proposal? Do you have copy of that letter? Proposal letter?
Very simple, my lord. If the police department requires to take the land which has already been occupied forcibly.
So should I send this representation again?
But the police is not denying my title. Police is admitting that they have already illegally occupied my land. Now they already.
That is the main bone contention of this case.
They have already requested the government to get the registration in the name of the police authority in respect of that particular land which I belongs. So where is the dispute?
So far, there is another case.
You file one report contending therein that whether what is the now status of the land.
Lots.
That will be better, I think.
We are the law officer of the court. This is our duty to assist the court, not to mislead the court.
That's why I am fixing. That's why clarification is required.
Because there is another case.
This week, the report may be called for with the demarcation further again.
Problem is that this petitioner is filing the applications for compensation and others on behalf of all.
No, his contention is true that your department.
Yes. That's report is also annexed. So for this case is concerned, but this petition is filing application on behalf of all the other disputed plots. So that is the problem.
So you should file
the
status of the land, whether it is within the possession of the department or with them. It will be better next week.
Yes, ma'am.
Next week?
Thursday. Because land is to be measured.
Mr. Sorenso appear for the petitioner submits. He is the registered owner of a piece of land measuring about 40 decimal meter. He is the registered owner of piece of land measuring an area about 48 decimals by virtue of registered deed of sale, being number 317 of 1973. Comprising LR Khatia number 197 pertaining to LR plot number 523 Mauza Uzanu, PS Matigara district, Darjeeling. The said land was encroached.
There are two plots, my lord.
Mention, I have mentioned.
This case is concerned.
Was encroached and raised boundary wall by the respondent number 3. Full stop. It is not disputed by the respondent that the land not belongs to the petitioner. Petitioner had filed 2 writ petitions with regards to the disputes earlier. Those writ petitions are writ petition number. Which page?
Page 27, Lord.
Writ petition number 26591. Writ W of 2013. In the said writ petition, the coordinate bench of the Honorable High Court, Calcutta, passed an order directing the BLNLRO Matigara to make an inquiry into the matter for identification and demarcation of the land in question. As requested by the Commissioner of Police, Siliguri Metropolitan Police. And then after submission of the report, the petitioner be permitted to raise boundary wall on the land belong to him in accordance with the provision of Siliguri Municipal Corporation Act. In view of the said order, a demarcation was made by the revenue inspector Pathorghata in presence of representative of the Commissioner of Police, Siliguri, and the writ petitioner Sri Tajender Lal Brahmin, duly represented by his lawyer Sri Anup Mitra, and the said report was communicated by memo number, page 31, memo number so and so, dated 31, dated 3rd May 2016. However, the land is in occupation. It is submitted that however, it is submitted that the land is still in occupation of the respondent number 3.
Yes.
In spite of that,
And it is admitted in the second writ petition. Page number 39. Order of the second writ petition.
it is submitted that
Second paragraph.
and what is part of and in the second writ petition, the respondent number 1 Principal Secretary, Department of Land and Revenue, was directed to take a final decision in the matter in respect of purchase of the petitioner's land. Full stop.
No, that was the submission of the principal.
It is a petitioner's land. And the writ petition was disposed of without calling for any affidavits, allegations contained therein also shall not be deemed to have been admitted by the respondent. In spite of such directions, the department has neither acquired in accordance with law or purchased the said property. The petitioner made a representation before the authority on 25th September 2018 and thereafter made a demand of justice through learned advocate on 21st August 2023. But that was not considered as yet. Accordingly, the writ petitioner came before this court with a fresh writ petition, with a similar prayer, with a prayer that the respondent is directed to initiate appropriate steps, including acquisition proceeding or acquiring the property through direct purchase and pay compensation amount or such compensation to the petitioner in terms of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. On the other hand, learned advocate appearing on behalf of the respondent submits in view of the Honorable High Court order dated the land has been already demarcated and segregated. And the land is not in possession of the respondent number 3.
Lordship. So for these two plots.
Your submission.
Lordship.
In this context, a detailed report is required to be filed before this court for proper adjudication, proper and effective adjudication of this writ petition. Therefore, the learned advocate.
In that case, my lord, commissioner may be directed to appear before the court also.
No. Report is sufficient.
Commissioner is not there.
Report is sufficient to adjudicate. Personal appearance is not required. So when you will
Thursday?
Next Thursday, directed to file a detailed report. Report with respect of the status of the in respect of the position of the land in question.
Last day, maybe.
Not Thursday, 19th, Friday khola ache to.
If report will come, I will decide on that day. No problem. By 18th. Because 19th is the last day.
Lordship, we will try.
18th. Let the matter be listed on so and so.
Another possible matter was there, number 2, item number 2.
Who is the other side?
Other side took the adjournment on that time.
I will call that matter at 2. Passover matter I will call at 2. All Passover matter, okay? Item number 7, please.
Number 17.
Yes, started on a similar matter. These two matters are not similar matter. Complications are there. GST matters, let the matter take place in the next week.
Next week.
Next week, difficult is because only revenue matter, since is taking division, then only 5. But I have heard next Tuesday and Wednesday there will be
Tuesday and Thursday.
Similar matter, please heard. I know the similar matter on Thursday matter.
No, what is the matter about?
Matter about this DGST and post GST contract.
Oh, yes. Yesterday you have submitted.
No other complex, similar matter. I have prepared a representation.
So when you want?
Similar ones. And the dates are the next are the last.
Next Sunday is the last day.
Then Tuesday.
Tuesday?
Tuesday, Tuesday, they are.
So you submit through virtual mode.
There are 4 or 5 matters already in education that Lordship may award.
So let the matter fixed on the next vacation, next available bench.
Monday I will appear partially.
Monday.
Monday.
Okay.
And, I am submitting my coordinate bench order. Yesterday I have submitted and.
Okay, I will pass on some order after hearing.
And
On 16. Huh? Affidavit of service is fine.
And all other documents I have submitted in the yesterday state. So only my coordinate bench, but order I have submitted.
You give it, you keep.
Only one, because I will appear partially. Only coordinate bench. I am not repeating all those judgments because I have already yesterday submitted all your judgment in the absolute case of Suhail.
On the affidavit of service file is taken on record. Learned advocate Mr. So huh? Short adjournment. Seek adjournment. Let the matter adjourn for the day.
But I am not taking adjournment.
And fixed on 16th. On the prayer of the 16th.
Monday.
Monday.
Which day, because that council from the principal will come on Monday.
He will appear on virtual mode. You ask also him to appear in virtual mode, no problem.
Yes, but all my people are here.
He will be not available, you will be available, then what is the matter?
I and Steve talked about SAR, we have to accommodate with that.
Tuesday you appear virtually, no problem.
Actually, because
Maybe, but you submit on that day, I will hear you. Even in any day, when after recess or after first recess, before recess. On Tuesday, 17th.
Because honorable chief
Maybe.
and also affidavit of service.
Yes. 16 and 17, both matter are fixed on 17. 17 and 18. Or 18, both are same.
18. 17 and 8.
18 or 17 and 18. Have you filed the affidavit of service in both cases? So I'll fix after Puja vacation. Both will be available, that will be better.
I'll try my time on Tuesday. I'm ready.
Serial number 19.
Lordship, I am appearing for the respondent Lordship, National Highways.
And for the state.
I beg to appear for the petitioner. This is a matter regarding to compensation. Compensation against land acquired by the National Highway authorities and money which is to be disbursed by the Special Land Acquisition Officer under the state government under the National Highways Act. Now, the petitioners, they were the owners of more or less 37 decimals of land. The ownership documents, the deed.
Have you served the copy?
Yes.
Where is the affidavit of service?
State is also represented, the National Highway authorities are also represented.
Both.
Yes, they are the only parties in the matter. Now, this land, after acquisition of the land, what has happened here? The ownership pursuant to the title deed is with the petitioners. The registered sale deeds are also annexed. But subsequently, what happened? The record of rights, the LR Khotian was also in the name of the petitioners. Now, after, if kindly sees the National Highways Act, I will place the provisions also. not required as of now. Milord, after section 3D, 3A notification is the first notification. After section 3D, when Milord, the land gets vested to the state in favor of the state, after section 3D notification, no correction of rights is possible or could be done. Because after 3D notification, the entire land automatically gets vested to the state. Now here what has happened, Milord, after the 3D notification, which was published in the Gazette, Milord, the block land and land reforms officer did a correction of records.
After publication.
After 3D notification, for reasons best known to him. And by strength of that correction, certain individuals went to the special land acquisition officer, showed his record of rights. I am the owner of this land. He took certain portions of money pertaining to this 37 decimals, which I claim it is my money. In that context, these petitioners earlier preferred a writ petition before this honorable court. Milord, kindly text Milord that order first. That is at Milord page 27.
Have you received any compensation?
Not yet, not a single penny. Now, Milord, I'll just show Milord what has happened. Milord, it is a very clear-cut case. Milord would take page 27 first.
Yes, 27.
27, Milord, is the first writ petition filed by these petitioners. Milord would find the names.
Yes.
Honorable Justice Rajshekhar Mantha considered this petition in presence of all the parties, and Justice Mantha directed the special land acquisition officer to consider the representation and pass a reasoned order. Now, Milord, subsequently, some hearings took place. Then, Milord, what has happened? Kindly, Milord, turns to page 41.
No, what was the decisions made by the authority?
I will just show that, Milord.
41, yes.
41.
Yes.
41, Milord.
This is another order.
Another writ petition, which that person who has taken away some money, he again filed a writ petition before this honorable court. Now, Justice Amrita Sinha also directed that his representation should also be considered and the hearing should be given to all the parties to scrutinize the documents, to call for records from the concerned land authorities, and to finally decide the matter who is entitled to the compensation. Now, pursuant to Justice Sinha's order, the special land acquisition officer, Milord, has conducted a hearing. That is, Milord, at page 64. 64 of the writ petition. Milord, while passing this reasoned order, Milord would find, Milord, reports from the BLLRO was called on. The DLLRO was asked to submit a report. A report was called from the ADSR also, on the basis of which deed that subsequent correction of records was done. It was found that that was done on a completely different deed, which has no manner of connection with these plot numbers at all. After detailed hearing, the special land acquisition officer made certain observations, which are the conclusions of the hearing. Milord would just skip over to page 66.
Yes, 66.
66, Milord, I'll just read out, Milord, the relevant conclusions, which are, Milord, relevant for the purpose of this writ petition. Milord, on the bottom of page 66, Milord would find, on careful perusal of the records available in the office, representations and submissions submitted by the petitioner and Tapan Mani Das and Jitu Mani Das, which are, Milord, the petitioners herein, reports of the BLLRO Kuchbihar 2 and DLLRO Kuchbihar, it becomes apparent to the undersigned that the plot of land under RS plot 1864 and 1864 Bata 2223 are separate and independent to each other. These are the, Milord, RS plots on the basis of which the record was cleared. The RS plot number 1864.
Your plot number.
Milord, my one is 4049 and 4050. Milord would see the next line. The RS plot so and so devolved into LR plot 4049 4050, while RS plot number 1864 2223 devolved into LR plot number so and so. The land was acquired in respect of RS plot 1864 corresponding to LR plot number 4049 4050 should be recorded in favor of Tapan Mani Das and Jitu Mani Das instead of Fuleshwar Das. As per the report of BLLRO Kuchbihar 2, the plot of land in question are erroneously recorded in favor of the instant petitioner. Instant petitioner means the Fuleshwar Das. Next, it is a fact that in terms of section 3D1 and 3D2 of the National Highways Act 1956, the land in question has already vested absolutely in the central government free from all encumbrances. Therefore, there is no scope for the BLLRO or DLLRO to conduct any hearing and make any correction in the ROR in favor of any individual private parties. And hence, no correction for ROR could be done after 11th of November 2011. And the correction was done in 2017. But interestingly, the said ROR was changed by the BLLRO Kuchbihar 2 in the year of 2017, which was absolutely illegal and erroneous. The payment of compensation made in favor of the petitioner by the then Special LO Kuchbihar was on the basis of erroneous ROR done by the BLLRO Kuchbihar 2. The petitioner was never entitled to get any compensation in respect of the land as mentioned here above. Necessary legal steps are required to be initiated against the petitioner for recovery of the amount. Moreover, during field inquiry, this is very important, during field inquiry it was found that Tapan Mani Das and Jitu Mani Das were in physical possession of the land in question. It is a fact that Tapan Mani Das and Jitu Mani Das are entitled to receive an amount of whole compensation in respect of the land as mentioned above. Now, despite passing this order, the 3A notification, 3D notification happened in 2011. The petitioners before your lordship, are rickshaw van pullers, extremely poor from the economically downtrodden section of the society. Since 2011, not a single money has been paid to them. The land has gone away. Now the National Highway will commence with the construction. Despite passing this order, I have not received a single penny. And on top of that, I am entangled in these litigations coming before the High Court once, contesting the other writ petition, and all these things are going on. Now, in view of this order, in this writ petition, I am praying that the Special Land Acquisition Officer be directed to disburse the compensation amount within 15 days.
What is the compensation amount?
Calculation has to be made in respect of 37 decimals. It should be around 40-45 lakhs to my estimate.
So from the decisions of the respondent number,
yes,
Special Land Acquisition Officer, it reveals that the plot of land belongs to
the petitioners. The deed is in my favor. The record of rights is in my favor.
Possession was also.
Yes. Possession, all the while possession was under my possession. That is recorded in the Special LO's order also. They have conducted a field inquiry. Miller would take page 25 and 26 of the writ petition. Miller would start from page 21. 21 is my registered deed of sale through which I have purchased the land. 25 and 26 is the record of rights in my favor, which has subsequently been corrected in my favor also.
The second writ petition was filed by the another writ petition.
Writ petition taken away the money.
Already
A part of the money.
part of the money has
Yes. And at page 57.
After this reason order,
Yes.
whether any case is pending
That I have to take instructions, my lord, whether the case is pending or not.
Regarding Millet?
regarding this reason order.
No case is pending. No case is pending, and there were 2 writ petitions which were disposed of by directing to conduct hearing. The entire thing was sent back to the Special Land Acquisition Officer for passing of a reasoned order. And this is the reasoned order. And Millard would kindly see page 57. 57, my lord, is the inquiry report of the BLLRO. My lord would take my lord the last paragraph.
Yes.
In addition to the above, a field inquiry on the matter was conducted through Revenue Inspector Morisbari Kholta. As per field inquiry report, the suit plot of land is in possession of Sri Tapan Mani Das and Jitu Mani Das, both sons of Jagadish Mani Das. Now, my lord would find,
On the
my
same.
lord, আমি শেষ করে নি তারপর বল। Millard would find the reasoned order which has been passed. Millard, that has been passed on 18th of September 2023. Only Millard, probably Millard 2-3 weeks, Millard prior to this date. The last page, 18th of September 2023.
So you are entitled as per your submission.
As per their submission, it is not my document. As per Mr. Das's client, his order I am entitled.
What is your submission?
Lordship, I am for the National Highways Lordship. Since the order is very clear, Lordship, we have already deposited the entire amount of the Moja Kholta. This case is relating to the Kholta
So
Moja.
who will pay the money?
Lordship, National Highway already deposited. Now who is the actual owner, that is determined by the competent authority. And the page 64 is very clear order, Lordship. Then we have no objection.
National Highway Millard has no role as on date because National Highway determines the compensation payable for the entire Moja and the deposit date at the time of 3D notification. So they have already deposited the money in 2014 or 15, the entire compensation payable to the Moja. Now, Millard, it is up to the state special land acquisition officer to disburse the money out of the total fund that they have received, the entitled compensation to the respective land losers.
What is
The issue is on threefold. Number one, the BLR report that is on page number 57. What my learned senior friend has submitted. Page number 57. The first part of the report sent by the BLR to the special land acquisition officer says.
Yes.
With reference to the above subject matter, it should state and inform him that as per available office record, it is found the total share of 0.37 acre of land in error plot number 4049 was recorded in favor of one Fuleshwar Das. So no, but this is the part where the BLO said there was recorded in name of Fuleshwar Das. In basis of this report, we have made certain payment with the special land acquisition officer made certain payment to the Fuleshwar Das. Now, my lord,
When you have made payment?
that I have to take instructions, my lord. I have not.
Because this order was passed.
Yes, 2022. In 2023, the same officer, the special land acquisition officer, is admitting that that has been wrongly prayed,
Yes, that's what I'm saying.
erroneously prayed.
And this record of rights was erroneous.
Yes.
Recorded.
Yeah, on the
That
data
is the
set was-
subsequent observation.
Subsequent observation, it was said by the special land acquisition that BLO report might have been erroneous or is erroneous. And the petitioner today is entitled to the claim. Now, what I am suggesting is one of this Fuleshwar Das, he has already received certain part of payment. He is required in this matter to make this submission. So the Fuleshwar.
Millard, what is his locus standi?
No.
You have created certain trouble with him.
Also,
and it is your officer, you have erroneously paid without verifying the records. Now you want Fuleshwar Das to be here. What does that suggest?
It's your duty to pay the original owner.
Yes, of course.
Why has the money gone to Fuleshwar Das? Let there be an investigation.
All this inquiry and reason order. Now it is very clear that the writ petitioner is the original owner.
Yes, from the order of the special land acquisition officer, that is clear.
And there was already direction to recover that money which was received by the Fuleshwar.
Yes.
Fuleshwar Das.
Now, why the state is interested in Fuleshwar Das? What is the reason?
He has taken the money. He has to make a submission.
There was a direction to entitled to receive the whole compensation as per.
In the order, the special land acquisition officer says that the money which has been paid to Fuleshwar Das has to be recovered.
Yes, that
Yes,
is also there.
now, Millard, what steps they have taken to recover the money? Now, whether you recover or not, that is not my call. That is their.
No
If
problem.
you pay someone erroneously, should I suffer for that? After 10 years to recover the money, should I sit for 10 years?
So this is a very clear case.
Well, let me just come back with the report from the special land acquisition officer and the BLRO. It's
After this, all the reports.
for this time. I'll come back with the report from both the special land acquisition officer and the BLRO.
All the reports are lying in the record.
No,
And after considering
clear.
after considering all the reports, this order has been passed.
No, for
Now, after an order is passed, it is a reasoned order. The reasons are there. My lord, on what point he needs instruction?
They are saying they have not been made any payment yet. Whether any steps have been taken or not, they have to take some instruction.
Special land acquisition officer is your officer.
Yes.
I need to take some instructions. So give me 4 days time. I'll come back with the
My lord, my respectful submission, my lord, since 2011, the two poor persons are, my lord, coming and going back from this court. Your officer has passed
After
an
this
order.
order, have you made any representation?
We haven't met, my lord, because we know until and unless this honorable court passes an order, my lord, no money will be disbursed.
That is apprehension, my lord. How can it be? Had they made a representation, I have given an order in his favor. We could have taken steps.
Is there any requirement to further report?
My lord, 4 days.
What report you need to
So at
file?
least whether any steps have been taken regarding disbursing their payment or not, number one. Number two, whether the BLO.
There is no need. If the direction will be given, that will be compliant.
If Millard kindly records.
Now another report, what you are on.
Yes.
Another BLRO, why the BLRO did this erroneous reporting? That is
That is your headache.
I understand.
Take
Give me
steps
4 days
against
time.
BLRO.
Just 4 days. I know the petitioner
Because
has.
everything is there.
4 more days.
Millard kindly passes an order. Millard kindly,
When you file.
Millard, if I may suggest this.
Monday.
Millard, if I may suggest this, kindly passes an order, the entire amount of compensation be disbursed within 2 weeks. If any amount has been disbursed, his apprehension is whether any amount is disbursed. If any amount is disbursed in favor of the petitioners, that will be adjusted. Matter ends.
But all this can.
Millard, these reports in this matter, Millard, if there is any lacuna on facts, there was a justifiable ground for them to take an adjournment on to take instructions. Where is the lacuna? It's your order. On the basis of reports of your officers, you have passed an order. Now again, another week for reports. Why?
It will, his case will become stronger if I.
No, I don't want a stronger case. I don't want a stronger case. I don't want a stronger case. I don't want the state to entertain Fuleshwardas anymore.
I will not entertain.
No need. There is no
Millard, kindly disposes this off.
No need to
Kindly disposes this off. Records that the petitioner's amount be disbursed within fortnight. If any amount has been disbursed in favor of the petitioner, that will be adjusted. Matter ends.
Well,
Let the matter to take care of Monday, we will submit the report.
No, why? Why?
Oh, this order totally passed, we borrow.
It will be better for you.
No, I don't want a better thing. The order stands at their face. Let them say that this order is wrong.
I'm not denying.
You are on the face of this order.
They will say in their report.
You have kindly then come back. Let them come back tomorrow.
Monday.
Tomorrow, Millard. Tomorrow, day after tomorrow, Millard. Kindly takes this up this week itself.
On Friday, you take.
Friday, yes.
Right, yes, sir. Get
Or both sides? Right? On the prayer of the learned advocate appearing on behalf of the state respondent, report be filed on 13th. Positively, because there is no other.
Yeah, I understand. It's just for our also this thing I have to submit a report.
Because I have to file a pass and revision order.
Yeah, I understand.
Friday, it will be taken on Friday.
Grateful.
Learned advocate appearing on behalf of the
Kindly allowed to take the matter Monday or
Monday.
At that time, service could have been completed.
How it will be completed?
Now, as per the status report, it has been at Siliguri head office.
On the prayer of the learned advocate, let the matter be listed on Monday, 16th. ওইটা লিখে দেবেন as the service is not completed as yet, হ্যাঁ?
In the 21 I am service has been completed. State Jalpaiguri will study. Not state. Directly.
All are Jalpaiguri municipality and one private respondent are also.
Also in the.
So have you served the copy to private respondent?
I usually apply for Jalpaiguri municipality. I don't think they have served upon us. I do not have a copy. I do not have a copy, my lord. Let him hand over a copy to me. I can do the matter, sir. Copy service হয়েছে কবে রিসিভ কবে হয়েছে হতে পারে হয়তো ওখানে ডিপার্টমেন্টও মিস করতে পারে হতে পারে আমার ইনসেন্স বলেন তুমি ইনসেন্স বলেন ইনসেন্স বলেন
What is the matter about?
My lord, the petitioner, the petitioner is the owner of the piece of land measuring 5 meter by virtue of P1 year, by virtue deed of sale. P1 page 14 to 16.
4 decimal or 5 decimal?
5 parts.
You have written 4 decimal in paragraph 2.
No, 4 decimals. 4 decimals. And a title suit is pending.
Paragraph 2 of the writ petition, you go through it. The petitioner has become the owner of the piece of land measuring 4 decimals. So you are submitting 5 decimals. How?
4 decimals. 4 decimals. And by virtue of ownership P1, the petition number 1 is acquired the subject land, and a title suit is pending for declaration injunction against the private respondent. You the learned media division, Jalpaiguri first court.
Where you have mentioned that?
My lord,
in paragraph 4.
my lord, annexure P2.
Annexure P2, yes. Yes.
My lord, the application under 39 was moved on contest, and after hearing the learned media division, Jalpaiguri was pleased to pass an order. Directly respondent restraining the private respondent to enter suit. And this is the order of annexure P3 over.
P4. Yes.
P3. Thereafter, the petitioner filed an application under section 151 of CPC for police head honor. That prayer was also allowed. Now this annexure P5, my lord, this municipality, Jalpaiguri municipality is private respondent raising construction on the suit land by the financial assistance of the municipality. So this petitioner made a recommendation in annexure 5 to the Jalpaiguri municipality to restore the funding and the financial assistance. And it is the aiding and abetting of the violation of the court's order. We made a recommendation by virtue of 5. Page 32, Your Honor.
Annexure 5, you have what representation?
To the chairman?
Representation?
Yes, representation.
Okay.
The chairman?
Thereafter?
Municipal board of councillor. That the petitioner raising construction of the suit land with the help of the financial assistance of the Jalpaiguri municipality.
So you are in not possession of the land?
We are, Well, after we were in possession, some portion of the land, only, some portion of the land.
Where you have mentioned some portion of the land?
Monetary representation subpart 2. Subpart 2, that now different program, the person revive or started construction in the portion of a student with the financial assistance of the municipality, and by this letter requesting to give list of the financial assistance for any illegal construction on a portion of the student.
Which paragraph?
By representation paragraph 2.
Not in writ petition. Why municipality is giving the assistance to construct the building or illegal construction? Why? To a private respondent?
I am for the municipality, I do not have the brief.
Asking. Why municipality will give assistance of finance to a private respondent in a private land?
My lord, it is the scheme of the municipality, by the.
Is there any scheme?
Yes, there is a scheme of municipality.
Which scheme they are providing assistance?
So we don't know the scheme, but they are providing.
So how you,
As for the instruction of the client.
how you can say that the municipality is giving us financial assistance? From where?
My lord, the petitioner said the representation, but they decided municipality to give an answer.
When you have given the representation?
Well, representation of. 12/7/2020.
What about the police help granted by the trial court?
Police is inactive. We filed content application. And also 12 of the content rate before the concern code even. Against the ICP municipality. They kept mom. Finally, paragraph 12, we mentioned the portion, my lord. Paragraph 12, the petitioner expressed that the written.
Who is the authority to consider your representation?
Hello?
Who is the authority? Who will consider your representation?
Chairman and board of
Chairman.
Chairman and
Board of Council. Chairman will be the.
Chairman and board of council.
Affidavit of service filed by the writ petitioner is taken on record. In spite of service, none appeared on behalf of the respondent. The writ petitioner came before this court. Averting that the petitioner is the owner of a piece of land measuring an area about 4 decimal pertaining to RS plot number 1421, corresponding to LR plot number 2016 in GL number 222 comprised in RS Khatian number 45 corresponding to LR Khatian number 294/1 of Pargana Muraghat. Page number 1 Moja Dhupguri under PS Dhupguri district Jalpaiguri by virtue of a deed of sale bearing number 2302 dated 15/12/2000 executed and registered by Nivarani Sarkar. The respondent number 4, private respondent number 4 hearing. Full stop, huh? Despite of transfer of the said land, the respondent number 4 having no right, title and interest tried to forcibly entered and disposes the petitioner from the land in question. You have filed the title suit.
Yes, it is pending for adjudication.
And for that reason, the petitioner has to initiate
But an injunction is there.
initiate a title suit for declaration of title and consequential relief before the Court of Learned Civil Judge, Junior Division, Second Court at Jalpaiguri, being title suit number 111 of 2014. And in the said title suit, a temporary injunction.
No, but a temporary injunction till disclosed. Temporary injunction till disclosed.
So a temporary injunction was passed by the trial court. Which P2.
P3. The order injunction will be approved.
अच्छा की लिखने में खाने
PC page 29.
trial court on contest restraining the defendant from disturbing or attempting to disturb in the peaceful possession of the plaintiff in respect of the suit property till disposal of the suit. Next file. It is further submitted. It is submitted by the learned advocate appearing on behalf of the petitioner that in spite of temporary injunction, the respondent number 4 tried to disposes and disturb the peaceful position of the petitioner. And for that reason, he has to file an application praying for implementation of the said temporary injunction under section 151 of the CPC 1908. What was the direction of the trial court in that that police held?
Legal position. Page 31.
31.
31. Then the petition order of the file was considered allowed without any order post. I should be going to have a directive to ensure that the order passed by the court on 4918 is not violated by the defendant.
That 51 151 application was decided on contest. Achha, yeah, ठीक है. The said application was also disposed of by the trial court, directing the IC Jalpaiguri PS to ensure that the order passed by the trial court on 4/9/2015 shall not be violated by the defendant or any person on her behalf. But no action has been taken by the police authority. Rather, the respondent number 4 is illegally constructing structure in a portion of the suit land with the financial assistance of Jalpaiguri municipality. And for that reason, the petitioner has made an representation before the chairman, to the chairman as well as the board of councillors, Jalpaiguri municipality, district Jalpaiguri. But the said writ petition was has not been considered as yet. So a direction may be passed to the concerned respondent to stop the illegal construction made by the respondent number 4, private respondent number 4, with the assistance of the municipal corporation. Having heard the submission and on perusal of the writ petition, it would be subserve the purpose of the writ petition if a direction be given to the concerned respondent, that is only one, respondent number 2, the chairman having in the office at Jalpaiguri municipality road PS so and so, is directed to consider the representation being P annexure 5, which has been appended with the writ petition. After affording an hearing, reasonable hearing to the petitioner through their learned advocate within a period of 8 weeks from the date of communication of the order of this court as well as writ petition. In accordance with law, and pass a reasoned order to that effect. The respondent is also directed to give an opportunity to the private respondent upon issuing notice for appearing in the said procedure. And communicate the final order to the party. Allegations, and this is the affidavit of sir.
Under heading motion, serial number 22 with 23.
Lordship, in item number 22 and 23, I am appearing for the respondent number 8. I am led by senior advocate Mr. Probal Mukherjee. Lordship, in these two matters, direction.
Miloj, may I 1 second? Miloj, I am appearing for the petitioner if my learned friend permits.
Direction of learned upon the BDO to file a report.
Well, the report is ready.
So we have not received the copy of the report.
Milords, we've also not received a copy of the report, Milords.
What the report states is that the land is not a PWD land. In the land in question, it was alleged that it was a PWD land where the construction is going on. After survey, physical survey conducted by the BL and LRO, it was found that it is not a PWD land.
PW land.
It is not a PWD land. It is a recorded land of the person who is making the construction.
Here?
Milords, I am appearing for the petitioner, Milords.
Unless we go to the, we will not be able to give our reply.
Milords, may I request, Milords, that the copy of report be supplied to us and this be kept, Milords, after 2 days, Milords.
Is there any advocate on record here?
Milords, I am for the petition. Milords, not in the court today, Milords, unfortunately.
So how he will serve?
Milords, by email, Milords, he can serve it to me, Milords. We need 2 days time, Milords, and then the matter be kept for arguments, Milords.
Let him provide his email. Placed to the next circuit. In the meantime. Yeah, locus matters.
Learned advocate appearance. The learned advocate appearing on behalf of the
State respondent.
Submit a report.
Of the
Dated-
PDO.
Report dated 2nd October 2023. Be taken on record. Learned advocate appearing on behalf of the petitioner as well as learned advocate appearing on behalf of respondent number 8 submits. No copy of the said report has been served, which is required to be served to file reply. Let the copy of the said report be served upon the
Lordship.
petitioner as well as respondent.
Lordship.
Number 8. Exception, I mean, reply to any exception to the said reply be filed.
Report, my lord. Exception to the said report.
Said report be filed on within 1 week.
Please, my lords.
From this day.
2 weeks.
2 weeks. From 2 weeks from this week. From date. Let the matter appear before the next circuit bench.
Next circuit bench after the puja bench.
Milords, may I seek your indulgence? Milords, may kindly see the last order in the second writ petition for a moment, Milords, which is 1725.
Yes.
Milords, the respondent, Milords, undertook to file an affidavit in opposition that has not been served. Milords, all I am requesting is if they are not willing to file any affidavit of opposition, that right be closed.
In item number 17, item number 27.
23, Milords. This is a connected matter, Milords.
Connected application. These are both the matters are connected.
Same.
There was a direction for the report to be filed in item number 22. That has already been filed.
Okay. And item number 23.
Item number 23. I
There's a direction to serve upon the Pradhan of the Brahman.
No, Milords, what I'm stating, Milords, is that the respondent said that they want to file an affidavit in opposition, but none has been filed so far.
The affidavit
So,
number
Milords,
1 has been filed.
You have already filed.
File on the next day.
Have you filed the affidavit in opposition?
It is ready not to on the next day.
Affidavit number filed by the respondent number 8 in the earlier
Now,
petition.
the opposite party, it is not filed with the court, will file on the next day.
What are the filed?
Milords, that may be recorded, Milords, because this is a 2021 petition.
Serve the copy as per direction, earlier direction.
Yes, Milords, all of that has been served, Milords.
Where is the affidavit of service?
Milords may see the last order, Milords. There's no direction on 1725.
The petitioner is directed to intimate this order immediately to all respondent and file an affidavit of service on the returnable date.
Milords, the respondents are before your lordship today, Milords. They are aware of these proceedings.
Panchayat authority, madam.
He is appearing on behalf of the panchayat only. Other respondent.
I don't represent the panchayat, my lord. I am appearing for the state respondents. Panchayat has to be served. It was the direction of.
Milord, all of them have been served. I will file an affidavit also. Milords may record my statement.
Of service, you file the affidavit of service.
We'll file, my lords, may record my statement that they have been served, my lords.
That will solve your problem without filing the affidavit of service.
My lords, I will file in the department, my lords. The only difficulty is I couldn't file it today because the matter appeared late last night. But my lords, they have been served.
So whether that is sufficient to record.
My lords, I'll file it on the next date, my lords, in that case.
File the affidavit of service in department, give me the number. And
I'll do that.
the affidavit service should be filed in department.
My lords, I'll do it, my lords, before the next date, my lords.
Millard places the same on the next circuit again, together.
না না ওটা তো আলাদা হয়ে গেল না না একই ম্যাটার না আলাদা আলাদা অর্ডার আলাদা অর্ডার হবে দিস ইজ 23
Milords, this is 22 only but connected, Milords. The serial number is same, Milords.
but separate order should be passed.
Please, Milords, please.
23 appearance new then somebody so it appears from the order dated 1st September 2023 passed by this court and directed the petitioner to intimate the order dated 1st September 2023 immediately to all the respondents and to file an affidavit of service on the returnable date. However, no affidavit filed by the petitioner. Learned advocate seeks to file the affidavit of service. When you will file?
Milords, within 1 week, Milords.
Within 1 week. Let the matter appear on 17th.
Grateful, Lordship.
Milords, this matter can also appear with the connected matter, Milords, subject to your Lordship's convenience. We'll file the affidavit in the department.
Would be taken on record.
Yes, I have already.
Grateful, Lordship.
Both orders should be passed in a single judgment.
My lord, actually, these two matters are connected matters. Can be done as a similar, one single order can be passed in both the matters.
So when the matter was fixed, that one, first one?
Milords, no date was given. It came up on 3rd October, Milords, last.
5th October.
3rd. 5th, there was a correction.
There was a correction made.
So after vacation,
The
Next circuit, my lord. Both.
both next circuit is one.
Grateful, Milords, grateful.
24.
Item number 24, Your Lordship. I'm conducting Advocate Mr. Arnab Shah, addressing this matter, Your Lordship. Kindly fix it 2 p.m., Your Lordship.
Why?
He is on the way. He came from Calcutta and he just reached in half an hour.
What is the matter about?
What is the matter? He instructed to give me submission, Your Lordship.
Who is the other side?
My lord, I'm appealing for the respondent, state respondent.
It may be fixed at 2 p.m.
Can be fixed. My lord, this was running in the list yesterday also, nobody appeared. My lord placed it as not today.
So at 2 p.m. I will come.
Grateful, Your Lordship.
25.
25 and 26, I am appearing for the petitioner.
One by one.
My lord, in item number 25, I am appearing on behalf of CGST. This is Central GST.
Service tax matter.
Service tax matter. My humble submission is that let the matter be fixed on 27. So, sorry, 17. That is Tuesday. I have to take some instruction. From the
Both
department.
matter, 25 and 26.
25 and 26.
Both service tax matter.
Both service tax matter.
Finance Act 1994.
What is your good name?
Ratan Bonik.
Mr. Ratan Bonik, learned advocate, appearing on behalf of the Central Good and Service Tax Authority.
Now
Central Goods and Service Tax.
Service tax now converted
CGST, in short, CGST.
Seek some time to take instruction.
Right.
Accommodation, to take instruction. Let the matter appear on 17th.
17, grateful, extremely grateful.
Under the same heading.
25 and 26, my lord. Same order.
Same order.
I'm grateful, my lord. But I will appear virtually, my lord. Kindly cooperate.
Okay, no problem.
Because my lord, only on Friday, our Chief Justice takes the revenue matter, my
Yes, I
lord.
know.
That is my problem. And last few months, some political matters, this, that, so we are suffering. That is why.
Okay, on Tuesday you will.
Yes, my lord. Yes, yes.
I can appear, I can argue the case on Friday also, but as per his request.
First Friday there.
Other several matters fixed on 17th.
Yes, yes, my lord. That is.
Convenient for
Yes.
him.
My lord, my lord.
On that day you submit all the.
My lord.
27.
Lordship, I am appearing for the petition.
With the other side?
I have served Lordship. This is the affidavit of service.
GST matter?
GST matter, Lordship, penalty, imposed penalty collected from wrong person being the petitioner here under.
In item number 27, this is also matter relating to GST.
1 minute.
The matter is called on. So pass over.
Pass over.
Let it pass over.
Lordship. Pass over, bathroom here.
Serial number 28.
For the petition.
Lordship, on earlier occasion, though the matter was, notice was served, but subsequently his lordship was pleased to ask me to issue notice again because the matter has been dismissed on earlier occasion. And this is the evidence of trial. Now the prayer is very innocuous, Your Lordship.
1 minute. The application is filed for restoration, recalling order, financial dismissal, it is available for the So your conduct is not good.
Lordship, actually on that date, where unrepresentative of the matter was dismissed, subsequently that has been restored by.
Where is the affidavit of service?
Now my submission would be with Your Lordship. There is an innocuous fear for an order of expeditious trial.
Your case number is, you have given the wrong case number. Number is correct, but the year is wrong in your affidavit of service.
Case number should be 137/2022.
But from the track report, it appears that no service has been affected.
Lordship, I have sent some official addresses through their designated email.
But no delivery was confirmed.
So for the private respondents are concerned, that is yet to be delivered.
So without confirmation.
Maybe fixed on next week, Your Lordship, we will take.
We take this affidavit back
Lordship,
and file a fresh affidavit.
Lordship.
On the prayer of learned advocate appearing on behalf of the petitioner, affidavit of service is not ready. Let the matter appear on 13th.
Grateful, Your Lordship.
My lord, I am for the petition. My lord, here, my lord, I have challenged the order of the landed civil judge junior division, my lord, rejecting my application. Under order 6.
This is first time.
My lord, this is not the first time, my lord. This matter is admitted, stay was granted, therefore there is a direction to serve copy to all the opposite parties. But my lord, what I have found, my lord, from the postal track, my lord, there are several opposite parties, 10 opposite parties, I think. My lord, some of them have, my lord, the postal tank says that some of the services have not yet been effected, my lord. My lord, 4 services not affected, other delivered, my lord. Since, my lord, there are 11 opposite parties.
Why you have not served the copy to the learned advocate for them?
So, my lord, in the last occasion, that is in the earlier week, my lord, there is a direction to serve. We have served, my lord, to all the respondents, and these are the postal tracks. So, postal track says that few of the services are not, my lord, affected. My lord, item backed or item booked like that. As others are delivered. Now, my lord,
Serve the copy to the learned advocate.
unless your lordship's direct file cannot serve directly to the learned advocate of the opposite parties of the trial court, my lord. If your lordship directs, I'll do that.
An insufficient address.
So, lordships, whatever addresses we have got from the, my lord,
Lower court record.
That is what, my lord, we have, my lord.
Have you tallied with the
Yes,
those address
yes, your lordships. Yes, your lordships. As per the plaint, my lord, then, my lord, as your lordship wishes, my lord, I will serve to the learned advocate for the opposite parties in the trial court, lordship. But in that case, my humble submission, lordship, can we keep it after vacation, my lord?
I'm giving. Affidavit of service filed by the petitioner is taken on record. Upon perusal of the affidavit of service, no service has been affected. Which respondent you have not mentioned? You mentioned which one served and which one not served.
My lord, I will clear it on the next occasion. Only one thing.
You write down in the letter.
Lordship, I will, lordship. In respect of those service have not been effected.
Yes.
Yes, your lord. My lord, only one submission, my lord. There is an order of stay. Can it be continued? Huh?
Because in such a situation, the petitioner is further directed to serve those opposite parties, respondent opposite parties, opposite parties through speed post as well as through learned advocate appearing through their learned advocate appearing in the trial court.
Lordship,
and file affidavit of service to that effect on the adjourned date.
Only one
submission. Yes.
My lord, initially, my lord, there is an order of stay that is subsequently extended. My lord, can it be extended, my lord?
So you have to file an application.
My lord, although, my lord, this is a very good.
You have to file an application for extension.
But it seems I have already got an order of stay that has been extended, although expired. Right at the moment, it has been expired.
So you have to file an application.
Lord.
Next.
I beg to appear for the petitioner. My lord, this has not been served. My lord, if I may serve and come back, my lord, after the vacation. Same order as the earlier one. My lord, there's only one opposite party.
What is the matter about?
It's regarding an execution application. Execution application not accepted by the court on the ground of delay.
So whether delay was rejected?
Yes. That is the, my lord, only point.
How long the delay was?
My lord, they are saying, my lord, the period of 12 years for filing of an execution has expired. We are saying that since it was an arbitration award, my lord, we had another 3 months. The period of appeal under section 37 should have been counted into it.
Okay. Not today.
32, my lord, I am for the, my lord, petitioner. If my lord takes the last order, my lord, there was a stay granted. Subsequent to that, my lord, there was a direction to serve. My lord, I have served. The affidavit of service is also on record. It was delivered, but the opposite parties are not appearing. So, my lord, I respectfully submit, my lord, can take this up and dispose it off, because the impugned order, if my lord takes, my lord, is absolutely without jurisdiction. My lord, kindly, my lord, seize the impugned order once. Now, my lord, at the impugned order, my lord would find there is a petition number passed by my lord.
What was the order?
My lord, it is an order dated, the certified copy, the 15th May 2023 order, my lord, is the impugned order.
Which page number?
My lord, the last page, the certified copy.
Yes. Order dated?
Order dated, my lord, 15th of May 2023.
The opposite party?
Yes. Now, my lord, before reading the order, my lord would kindly notice the first thing, that is, my lord, this was a petition which was, my lord, purportedly registered under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. Now, the petitioner and the opposite parties, my lord, they are adjacent shop owners. There was a dispute regarding a piece of land. Now, on the basis of that, my lord, I do not understand this, my lord, how this application was preferred at the first instance, because for an application under this act to be entertained, they have to be relatives. And who are the relatives under the 2007 Act? That is defined. Senior citizen, their children, grandchildren, daughter-in-law, but there has to be a relationship. Now, they are adjacent shop owners. Despite that, my lord, the executive magistrate exercised powers under the 2007 Act. And in the 2007 Act, an order has been passed directing the petitioner's eviction from a particular point of view. So, on the glaring facts and circumstances, when the first time this matter was taken up, this honorable court granted a stay.
Who is the opposite party?
He's an adjacent shop owner.
The neighbor?
Neighbor. Shop owner. The dispute is regarding two shops.
Have you filed that application here?
Yes. That application is also there. My lord would find page 42.
Yes, 42.
Yes.
Kindly read it.
Now, my lord, kindly see the subject. বৃদ্ধের দোকান প্লট গ্রাস করার চেষ্টার মামলায় অপরপক্ষ হেরে যায়, সিনিয়র সিটিজেন হিসাবে দোকান খোলার প্রার্থনা. This is what it is. Now, let's see the দরখাস্তকারী অতুল চন্দ্র দাস.
কোথায় হেরে গেছে? Where he lose?
Yes, my lord.
Where he lose the case?
My lord, I don't know. Where he has lost, I don't know. He has written here, মামলা করে অপরপক্ষ হেরে যায়, সিনিয়র সিটিজেন হিসাবে দোকান খোলার প্রার্থনা. Because so far as our knowledge goes, there was a civil suit pending I preferred a suit for permanent injunction. That suit, with a flux of time, I did not press that suit. That suit is now dismissed for default. So AJAY is not applicable. Now kindly see what he has written. বিনীত নিবেদন এই যে অদ্দূর নিরুপায় হইয়া আপনার নিকট শরণাপন্ন আমি একজন উদ্বাস্তু দেশ ভাগের বলি হয়ে 1947 সনের পর আলিপুরদুয়ারে এসে সেলাই মেশিন চালিয়ে ঘর ভাড়া ঘরে দোকান করার পরে পরিবার বাবা মা সকলেই প্রতিপালন করে নিম্ন তপশিল বর্ণিত ভূমি 1999 সালে দানপত্র মাধ্যম মালিকগণ্য হইয়াছি। আমার দুই পুত্রের মধ্যে বড় পুত্র 100% প্রতিবন্ধী, ছোট পুত্র সঞ্জয় দাস তাহাকে দোকান ব্যবসা হাতে তুলে দিয়ে বিবাহিত দুই সন্তানের পিতা, বর্তমানে সদস্য সংখ্যা 7 জন। নিম্ন তপশিল বর্তিত দোকানে লতাশ্রীর দ্বারা আমরা প্রতিপালিত হইতেছি। অপরপক্ষ সে প্রচন্ড লোভী, তাহার জনবলে অর্থ বলে বলিয়ান, সে আমার দোকানপাট গ্রাস করার জন্য অত্যাচার শুরু করে। হি ইজ দ্য অপরপক্ষ, দ্যাট ইজ কমলচাঁদ বোত্রা। থানা ব্যবসায়ী সমিতি এসডিও মহাশয়ের নিকট জানাইলে সে
is the present petitioner.
Yes, কমলচাঁদ বোত্রা is the present petitioner. Now let the second paragraph. বর্তমানে জনবল অর্থ বলে বলিয়ান আমাকে উচ্ছেদ করিবে, এই অবস্থায় আমার ব্যবসা দুর্বল হয়ে পড়েছে। স্বামী স্ত্রী দুজনই সিনিয়র সিটিজেন, দ্যাট ইজ দে আর স্পিকিং অ্যাবাউট দেমসেলফ। বড় পুত্র প্রতিবন্ধী, সে শয্যাশায়ী চলার। অপরপক্ষ কমলচাঁদ বোত্রা উদ্বাস্তু না, সে একজন পুঁজিপতি। সরকারি জায়গায় বিল্ডিং, পুঁজিপতি স্থান হবে সরকারি জায়গায়, কিন্তু উদ্বাস্তু স্থান সরকারি জায়গায়। এই মর্মে 123 ধারা মোতাবেক আমার সীমানা লঙ্ঘনকারীকে আমার 77 বর্গফুট জায়গা ও দোকানঘর সহ সুরক্ষিত করে উপযুক্ত শাস্তি বিধানে ব্যবসা রক্ষা প্রতিপালনে আজ্ঞা হয়। Now, with due sympathy to what he has stated, there was no occasion for the subdivisional magistrate to register a petition under the Senior Citizens Act.
A senior citizen act, senior citizen act. Kindly read the order of.
Yes, now let's see the impugned order. The OP
Appeared with his learned
the OP along with his learned advocate, the petitioner appeared. After hearing the OPs, the OP stated that the case is Maintenance and Welfare of Parents and Senior Citizens Act 2007, dues not this matter. This is, Milord, was the submission of the OP. That, Milord, the OP is the petitioner herein, that this act does not apply in this matter. The petitioner filed a petition regarding a case initiated by SDO and Milord passed an order, but the OP filed a case vide TS. This was the Milord title suit which I was referring to. TS2 of 2006 regarding this matter. Peruse the case record. The fact is, during construction of widening of PWD road, the shop of petitioner is demolished and prayed for contiguous to his shop. Considering the above fact, the order dated 2nd January 2016 by the SDO Alipurduar is hereby upheld. The Sri Atul Chandra Das, proprietor of MS Latasri, may be provided a minimum quantum of space, preferably 6 feet into 8 feet, contiguous to his present possessed area, which would be demolished.
Sri Atul Chandra Das is the opposite
party, yes, which would be demolished in connection, in consultation with Kamalchand Botra, that is OP, and also with Alipurduar Town Babshayi Samiti. Informed to all concerned, the case is disposed of. Now, Milord, how the SDO can, Milord, pass an order directing me to offer a land to someone?
What is the order up to 2nd January 2016 by the SDO?
2nd January 2016, Milord, they had earlier preferred a petition in that is, Milord, at page 33.
Yes, 33.
Milord, find Milord 4th January 2016. Milord, this is the order which has been referred to. Milord, both Atul Chandra Das, proprietor of MS Latasri, Kamal Chandra Botra, proprietor, attended the hearing. Sri Poritos Das, General Secretary on behalf of Alipurduar Town Website, was also present during the hearing. Heard both Sri so and so and also gone through the report dated so and so submitted by Sri so and so, General Secretary, Alipurduar Town Website Samiti. During hearing, neither Sri Das nor Sri Botra could produce any valid documents for establishment of their possessed area as their written land. It appears from records that both are in possession of government land. However, it was brought to the notice of the undersigned that the entire shop of Sri Das to be demolished in connection with expansion of the existing PW road for public purposes, and he has no scope to run his business at present. As a result of which, Sri Das is in dire need of suitable accommodation for arranging bread and butter of his family. It is also seen that Alipurduar Town Website Samiti has taken up the matter seriously to resolve the problems cropped up between Sri Das and Sri Botra. Considering the fact above, it is therefore suggested that Sri Atul Chandra Das of MS Latasri may be provided a minimum area of space, preferably 6 feet into 8 feet, contiguous to his present possessed land, which would be demolished in consultation with Sri Botra, who I think will extend necessary cooperation, keeping in mind that under no circumstances the ongoing expansion work of the existing PWD road in the interest of the public services is disturbed anyway. Inform all concerned.
Who is Sri Botra?
The petitioner herein, Kamal Chand Botra.
So there was an order for adjustment.
There was an order of adjustment. You provide land, and now my land which I am possessing, Millard, is pursuant to a lease deed of the government. That Millard was prayed for me before the civil court. Now subsequently during that point of time, this opposite party was attempting to encroach into my shop. Long-term lease, yes. It was a long-term settlement in my favor. Now, how can Millard, under the Senior Citizens Act, the SDO can exercise powers in a dispute like this?
What is your prayer now?
Well, my prayer is this order should be set aside. This is absolutely without jurisdiction.
Which section you are providing?
Yes. Now, Millard kindly takes, if Millard takes the act, Millard takes 2 subclause G. 2 subclause G.
2 subclause D.
G. 2 subclause G of that.
G.
Relative. Millard has got it?
Yes.
Relative means any legal heir of the childless senior citizen who is not a minor and is in possession of or would inherit his property after his death. Minor has been defined in 2C, not applicable here. 2A is children. Millard, against whom proceedings can be initiated under this act. That is Millard, section 2 subclause A. Children include son, daughter, grandson and granddaughter, but does not include a minor. And senior citizen has been defined anywhere who is above the age of 60 years. Now, Millard would go through the act. Section 4 deals with maintenance. When a senior citizen is aggrieved that his children is not maintaining him or her, he can prefer an application for maintenance. 8.5 is Millard application for maintenance. 6 is jurisdiction and procedure. And next, Millard would take order for maintenance, that is section 9. If children or relatives, similarly, a proceeding under the 2007 Act can be directed only against the children.
Must be relatives.
Correct. Children or relatives?
Relatives.
Children or relative?
Or parents.
Parents.
Only parents or relatives.
Parents or relatives. Now, Millard, the 2007 Act deals with only 2 things. One is maintenance. The second is cancellation of gift deed. If, Millard, a gift deed is executed in favor of a children and after receiving the property does not take care of the parents, the powers under this Act can be invoked for cancellation of the deed. These are the only 2 things which can happen under this Act, 2007 Act. Now, my lord, how the SDO can invoke this act to pass an order in a dispute in between, my lord, two shopkeepers? They may be of 60 years.
But there is no relations between.
No relations between them. And section 23, my lord, would find transfer of property to be void in certain circumstances. That is section 23. That is, my lord, the cancellation of gift deed or any other conveyances which a parent may execute in favor of a children, and subsequently, if the children does not take care of the parent, that transfer can be declared as void by the tribunal. So, on the basis of these facts, my lord would find on the first day when this matter was heard, this order was immediately stayed. And there was a direction to serve upon them. That was served. The affidavit of service is there. Despite receiving it, they did not turn up. My lord would kindly take the earlier order passed by Justice Tandon. My lord, the third paragraph.
Where is your affidavit of service?
It is on record, my lord. On the last occasion, my lord, it was filed on the record.
No, there was a direction for it is directed to serve on 10th August 2023. Thereafter, you have not served.
10th August, my lord, it has been served, but that affidavit of service, my lord, has not been prepared.
There was a direction.
Yes, but my lord, pursuant to the earlier direction.
After getting a stay order,
yes,
there was a direction. Petition is directed to serve a copy of the instant revisional plea upon the respondent by speed post and self-file affidavit of service on the returnable date.
That has been served, my lord, but that affidavit of service is not there with me today.
Tomorrow?
Tomorrow,
Have you
yes,
served?
yes. Tomorrow, it has been served. It has been served.
It is
Tomorrow.
confirmed?
Yes, yes, confirmed.
Service is confirmed?
Yes, service is confirmed.
So tomorrow I am.
Tomorrow, my lord, I'll make the affidavit of service available.
Tomorrow I'll.
Yes.
No affidavit of service filed in view of the direction passed by this court on so and so. Let the matter is adjourned for the day. Petitioner is directed to file the affidavit of service.
Yes.
On the agenda. On the agenda.
I can say I'm seeking for short pass over lordship.
Short pass over.
34. 34. 35.
35, my lord, I am for the petitioner. My lord, this is, my lord, against an order of, my lord, rejection of my application for preemption under section 8 of the WBLR Act. But my respectful submission, my lord, if this can stand over till, my lord, the next circuit after the vacation. That is appearing for the first time, or in the meantime, my lord, I can serve and come back as my lord desires. My lord, to be very candid, my lord, I am not ready with the matter.
The next week you can do it.
But after the vacation, my lord, it's a preemption matter, my lord, I have to go through the entire record. My lord, I can serve and come back. My lord can pass an order for service. By the vacation ends, my lord, the service will also be complete. My lord, it can be taken up and heard out.
There is a motion stage, so let us.
My lord, then, my lord, kindly simply, my lord, the next circuit.
Okay, on the prayer of answer, let the matter appear on the next available circuit bench.
Grateful.
1 minute, 1 minute. You have called, already called? No. Okay. That matter. Which item?
27, Lord.
27.
20. This is the affidavit of service.
This is also relating to GST.
GST.
So, when you will be available?
Lordship can do if your Lordship can. Lordship can do one thing. In the last order, there is a direction to take steps for recovery in accordance with law. So let them submit a report and matter may be placed after the vacation, Lordship.
That can be done.
My friend will be happy. Affidavit service may kept with record. This.
Whether recovery has been made.
Recovery has been made from me wrongly. My goods were transported. These are all regarding the asking machinery from my own articles, which already purchased upon payment of GST. And it is transported from Bardwan to Assam on a hire. Now, subsequently, when it is returned back, at that time, the GST authority intercepted that lorry truck. And that is their allegation in the case, Lordship, that there is a little bit mistake is there, that one document which is referred in the EOA report that was not written in the original document. This much. Against that, they have imposed the 5 lakhs.
No, so show cause notice was not issued.
Show cause to driver. I was not served any notice, anything.
Why you have not come forward to them?
Lordship.
Why you have not appeared before the authority? You
because
have to come forward.
I had been there.
Because that goods belongs to you.
But yes, no, they have released the goods and upon the goods no penalty is imposed.
Okay.
Nothing.
Oh, goods.
Yes, goods are released. My case is this, that only they impose the penalty upon the truck owner.
Okay.
Now, one fine morning over phone, the deputy commissioner told me that if I won't pay the amount, penalty amount on behalf of the truck owner, in that case, he will not release my article. So naturally, I am a layman. I am a businessman. So I have deposited. He sent me the challan and all these things. I paid the amount.
Now what remains? You have paid the.
But they can't take it from me. And there are other question also involved there. But at this stage, since there is an order.
So what type of report they will file in this case?
Because according to me, they should have recovered the amount from the owner of the vehicle.
Not from you.
Not from me.
This point has not been raised before the authority by you.
Happy provision is also there.
Yes.
No, there is a summary revision provision against that because I was not party.
So you have not raised before the authority this issue?
No, in the reply it is stated that I am the owner. Reply made by the driver. He stated all these things. But apart from this, that order is passed and ultimately the penalty is taken from me.
But that order you have to statutory challenge before the appellate authority.
No, because Lordship, I was not included in the proceedings. I was not served any notice. Even in that case, if your lordship may hear the matter,
you are aggrieved with the said order.
Then because the proceeding itself initiation is bad, Lordship, then I have to go through the records, Lordship. Then I have to go through the statement.
What type of report they will file? What type of report you want in this case from their end?
What relief?
No. What report? Just now you submitted.
Because that in the last order, this honorable court has been pleased to pass an order to initiate a proceeding for recovery proceeding on my submission, on the basis of my submission. That or in accordance with.
Already submitted that the recovery has already been made. So again, why initiation of proceeding will be initiated?
No, proceeding not initiated. My amount to be refunded.
No such order is there.
That order is not there because it is the preliminary stage, no service of notice not completed at this stage.
Only the order is pendency of the writ petition will not create any equity in favor of petitioner and concerned state.
And recovery.
Are directed to take all necessary steps in accordance with law for recovery of the.
For recovery process.
So
that order was.
That you have submitted that you have already recovered amount from you, not from the driver or owner of
owner
the
of the
vehicle.
vehicle.
When you
How many people of the
refund,
refund? Since then, you can appeal it for in the proper.
what is your prayer in this case?
Lordship, there are twofold prayer. In first prayer, Lordship, I prayed for refund of my amount. And in prayer B, Lordship, I pray for quashing of the initiation of proceedings. Because Lordship, kindly have a look on the.
So proceeding has been initiated against you.
No, not against me, against the
So-
driver.
Show me the order.
Yes, Lordship. Lordship, kindly have a look on page 45, statement of that pay, annexure P4, page 45, 46, and thereafter notice.
No, 45 is the statement.
Statement.
Yes.
Now, how they taken this statement from the driver, Lordship, kindly
They will
observe.
take,
It is a printed
from
format.
whom they will take the statement? When
The
the
printed
when the
format.
vehicle were.
Driver is a layman about English. They should have narrated the entire facts to the driver.
That is the representative of the owner.
Driver not representative
Driver
of the
was,
owner. Driver is the in
driver
charge.
was
of the
present in the spot.
Driver is the in charge of the vehicle.
Maybe that the driver was the
In charge of the
person who was present at the spot where the vehicle was.
and they are replying also here.
And where is the order of release of your goods?
Lordship, that is a page 67 and type copy I have annexed.
67.
And Lordship, kindly have a look, page 67 to Muhammad Imdad.
He is also driver.
He is the driver.
So goods returned to him,
Goods returned to him.
not you.
No, the seized article returns to me. It is delivered to me.
Where that order or release order?
Thereafter, Lordship, I am coming to that. In view of the above goods and conveyances
Which
have been
page?
deleted. That is page 67, last line.
7-1 A, B, C, which one?
67, only page 67, release order.
Only 67.
Only
Yes,
67.
67. Yes, in view of above, the goods and conveyance are hereby released on so and so. So it was released to the driver itself.
Driver itself.
So where is the penalty?
Penalty
Imposed upon him?
Lordship, I have paid. Before that penalty is here, Lordship,
Under which section they have imposed penalty?
When the goods were released on as per section 129 of the GST Act, they has to file 129(1)(a) on payment of applicable tax and penalty equal to 100% of the tax payable on such goods, and in case of exempt goods of payment of amount. They have paid the.
Yes, you have paid the penalty.
100% tax, but no tax is imposed. So question of tax doesn't arise. Question of penalty doesn't arise unless I have not paid
You
that.
have sought the copy of form movement that
Only after penalty, only after penalty. I have annexed all the documents, Lordship.
GST movement 07
Lordship.
and GST movement 06. You have served. And on the basis of that, you have
Lordship, kindly have a look on 28 June, I have served after passing penalty order. On 28 June, that is 52 page. He sent me the penalty, he sent me the order he passed.
52.
Through WhatsApp, 52, through WhatsApp. Through WhatsApp.
23rd June and 23rd.
23rd June, that was the initial initiation of proceedings. Right.
In any case, Lordship, there is an order, the duty authority at page 678. There is a separate order remedy available to they have to file appeal. If they are agreed, they have to file appeal under section 107 of the GST.
But there was no order.
No, there was no order.
Only show cause notice was issued. On the basis of show cause notice, they did not reply. They have paid the penalty.
That is for the purpose of releasing.
Releasing of the goods. So you have to give the reply.
No, I have not served,
notice.
I have not served any show cause notice. No, show cause notice is served upon the driver and he replied. He replied. Relying that reply, the penalty order is passed. The moment penalty order is passed, thereafter only the copy of challan has been sent to me on 28th after passing order.
So the 129 is very clear. If you come, then you have to pay. I will come after.
Lordship will take up the matter too.
Yes, I will take up and I will dispose of.
Lordship. Lordship.
Please submit date wise, then it will be better.
Lordship. Lordship, before my submission, Lordship, I am saying that I am not placing prayer B, only I am placing the prayer A before your Lordship to refund my amount.
Prayer B only.
Only prayer A.
No, prayer A.
A.
Right. Yes, prayer A is
Refund the amount.
whether you have deposited that amount subject to result of the case or anything.
Yes, I have
or without
deposited them.
prejudice.
I have deposited.
Whether you have made a condition before the authority.
No, because it is, they have sent it through WhatsApp when because I am residing at Burdwan.
So you have accepted their proposal to deposit penalty.
Because at that time, nothing to do. I have nothing to do in WhatsApp in the night around 9:50 p.m. on 28th. They have sent it through WhatsApp with a
when
copy of.
your vehicle was intercepted.
Now I am coming to them. On 19th, the vehicle was intercepted by the Alipurduar.
Okay,
19th of
2023.
June, 19 June.
19/6/2023. Yes.
19 June, vehicle was intercepted.
Okay.
Thereafter, the statement was recorded from the driver being the person in charge of the vehicle. In the vehicle, I have 3 harvesting machine which was transported to Assam and returned back. During return back, it is intercepted by the Alipurduar.
You supply to the Assam.
Assam.
So you have delivered the goods.
No, harvesting machine. It is purchased against the GST, Lordship. Not delivered for discharge the service. For harvesting purpose, I have
harvesting purpose.
For harvesting purpose, I have sent it to Assam.
Okay.
And while it is returning to Burdwan.
How many machines were there?
3 machines were there.
Yes. Thereafter.
And Annexure P1 is the bill of the machineries. While this will be appeared that I have paid the GST and necessary GST at the time of purchase of said machineries.
Way bill page.
Lordship. It is page 38 to 40.
38 to
page 38 to 40. These are the bill.
Yes. Thereafter.
Now thereafter, while it is returning, then with some certain allegation about noting of one point, that is the documents number, the vehicle was intercepted by the deputy commissioner, and he issued show cause notice to the driver. Everything is in the name of driver.
On 23rd 6/2020.
On 19th and thereafter on 21, the show cause was issued. So he complied with the formalities, whatever is there regarding the vehicle, regarding the vehicle's Lordship. Now, Lordship, I am to this point. My case is very short. I am not going to the whether that is correct or wrong or any illegalities is there. I am not challenging the order itself. My case is very simple.
No, I have understood your case. I am asking you the date of their action taken by the authority.
Within 7 days.
Within 7 days.
Within 7 days.
So, impugned ex parte order was passed.
Impugned ex parte order was passed.
On 28/6/2023.
On 26 November.
Thereafter, that order was communicated
To me in the night over WhatsApp.
Okay.
But the impugned order is also passed with their findings. Lordship, kindly have a look on the findings. Last paragraph. I'm coming to that page, Lordship. Page 67, type copy, because the original copy is not readable, Lordship. Only 2 points I'm just placing before your lordship. Lordship, paragraph, second paragraph, 67I.
67.
I.
Yes, I.
Second paragraph. A penalty imposed for a tax delinquency is a civil obligation. Remedial and coercive in nature and far different from the penalty for a crime or a fine or forfeiture provided as punishment for the violation of criminal or penal laws. So there is no penalty, there is no action taken by the authority against me. Since my vehicles are in civil in nature, against that no offense is there. Offense is against the truck, lordship, because it is, as per their case, it is plying without the proper documents. Now in the second, third, fourth paragraph, in view of above facts, the transportation of the aforesaid goods is held to be in contravention of the provisions of 68(1) of the WBGST Act 2017 and CGST Act so and so read with other provision. Therefore, the plying of the vehicle is without documents and penalties against the vehicle. That's why the show cause is issued against the driver. Proceeding is initiated against the person in charge being the driver. Order is passed against the driver, not upon me. Now in the last line of the said order, lordship, the total demand stand as rupees 5,08,508. Now you are hereby directed to make payment forthwith not later than 15 days. So this direction also upon the driver. Why they send it to me?
Okay.
Everything is against the driver, against the plying of the vehicle. Regarding my articles, there is no allegation or no tax is imposed. And unless tax not imposed, penalty cannot be imposed. So regarding my articles, there is no tax.
In paragraph, specific awardment was made in view of the above fact that the transportation of aforesaid mentioned goods is held to be a contravention of provision.
Transportation, not goods, lordship. Not goods, transportation, subject to your lordship's correction. Transportation of the goods, not against the goods. So if I am not within the ambit of penalty, lordship, why they have taken this money from me? Why they sent it to me?
And where is the receipt you have paid?
Lordship, deeply obliged, lordship.
And how much money you have paid?
Entire amount, what they claimed. Lordship, that is page 65, 66.
Entire amount means 5 lakhs.
5 lakhs 8,000. Page 65 is the challan. Challan receipt 65, 66. And thereafter the 67 is the release order.
60 challan.
65, 66 is the challan. Payment receipt. Lordship, at the middle, lordship, 5 lakhs, 2,54,254. In total, 5 lakhs, 8,508.
The receipt was issued in favor of the driver, not in favor of me.
Not in favor, in the name of me. And the second thing is, lordship, my learned friend then said that.
You can say that you have paid. When the receipt is also issued in the favor of driver, how you can say that you have paid the amount?
Lordship, because it is deducted from my account, own account.
That may be. But notice was issued against the driver.
Lordship, it is under
order also passed against the driver.
Yes.
And money receipt is also in favor of the driver.
No, money receipt not in favor of the driver.
Yes, name Muhammad Imdad. Not in favor of you.
Which page, Lordship?
65.
Receipt
65, it is paid by me. My name is there, Vishwanath Devnath.
65.
Yes, Lordship.
Where is
At
it?
the bottom right side.
What's a text? But in the left side of the GST number, in whose name?
obviously will be on the petition.
No, GST number is in my name. There is no dispute. There is no dispute. And GST number is in my name. Payment is made by me. That is also, the record itself says
yes,
what is my claim. But the order is passed against the person in charge of the vehicle, being the driver.
Now come to 129 section.
Lordship.
What 29 says?
Lordship, unfortunately, book is. Can I open my book?
Oh, you are okay.
Lordship. Notwithstanding anything contained in this act where any person transports any goods or stores any goods while they are in transit in contravention of the provision of this act and rules made thereunder, all such goods and conveyances used as a means of transport for carrying the said goods and documents.
So transportation for carrying of the said goods. It relates to transportation of the said goods.
Said goods.
Then
For transportation.
yes. And here is similar transportation of your goods.
Of my goods, but against my goods there is nothing.
Now you go through the section. Thereafter what written?
বই তোমার কাছে বই আছে এক মিনিট
All such goods and conveyance used as a means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention.
Yes, Lordship.
Or seizure, and after detention or seizure shall be released.
Lordship.
When it would be released? Condition A.
On application of payment of the applicable tax and penalty.
200%
tax
of the tax payable on such goods. And in case of
yes, I admit this. I admit I am not disputing this, Lordship.
I am coming.
Lordship.
On payment of any amount equal to 2% of the value of the goods or 25,000 rupees, whichever is less.
Lordship.
Where the owner of the goods come forward for payment of such penalty. So you come forward before the authority and you paid. Why you have paid? Because the goods belongs to you.
No, goods belongs to me, but unless there is no tax, the question of penalty doesn't arise.
That is the tax calculated in so-called notice.
There is an order at page 67.
An order itself is there.
Amount has been prescribed.
What would be the tax? What would be the penalty? The condition itself mentioned in 129A. So you have, this is the admitted position that the goods are belongs to you.
No, there is no dispute.
So
There is no dispute.
So when you have come forward to release your goods and you have paid according to the provision of GST. So what remains?
Even, Lordship, what is my case? Lordship, kindly, subject to your Lordship's corrections. Unless there is no tax imposed upon me, unless.
Me means driver, me means conveyance, me means goods.
May I hand over the notification? Procedure has been laid down specifically on the basis of this notification.
And against that order, if you feel dissatisfied, what is the provision?
There is a separate appellate provision under 107.
No, a question of appeal because there is a provision also revision under the order of the commissioner.
Either you.
So motor revision is there.
So I am giving you liberty to go.
So motor revision is there. I have stated in my petition
on your application, both.
Before the joint commissioner, Lordship, as per this order.
So there is an alternative efficacious remedy. Why you have come here? There is no any illegality. Is there any illegality in detention?
No, since during detention period, they have not come. It is only upon.
Is there any illegality in the order itself? Even then, you have to go for your grievances before the appellate authority or revisional authority, whoever may be applicable to you. This is very simple case.
Lordship, in that case, Lordship, since there is a provision for Somoto revision. Yes.
Which section you are reading?
This is the order by commissioner.
Which section you are reading?
No, this is as per order of the commissioner who is authorized to pass. So according to, I am handing over it to just I read out. To require a transport to stop a goods vehicle to produce the waybill and documents referred to in subsection 1 and countersign waybill. So this is by senior joint commissioner, commissioner tax joint commissioner, including the deputy commissioner. He stopped the vehicle. Now thereafter in 27 to revise Somoto an assessment or an order passed by a commercial tax officer or assessment commercial tax officer.
What is the contravention? Can you say?
Lordship,
what is the contravention of the law?
They have stated 129.
129A.
A.
That is the provision for penalty. Where is the so cause notice? Which page?
Okay, page 47. That is the detention order, and in view of the aforementioned goods conveyance required to be detained for further proceedings.
47.
47. This is the detention for further proceeding. 47 to 51 and 53. No show cause is communicated to us. Maybe show cause issued, perhaps. That is not communicated to us.
The goods not covered by valid documents.
That's for 16(1). And hearing was done in India present. They were acting as their file.
No, I have not filed any written. Never.
Order speaks. Order
speaks about the driver.
Yes.
They filed the written reply.
What are the valid documents you have filed here?
That is first.
Show me the document.
First thing is my CGST bill, purchase bill.
Which paragraph? Which page?
Page 38 to 40. And then Lordship, page 41 to 43, EOA bill. Only one thing is there, only one number is not quoted in the EOA bill.
Which number?
4, serial number 4. I'm coming to that. Page 41 to 43. Only this discrepancies is there.
So I'm giving you liberty to approach before the authority because you have already deposited amount, so you approach before the appropriate authority. Who would be the appropriate authority?
Lordship, Joint Commissioner is the authority. As per this government order, as per this order passed by. Who can sumoto revise this order?
Sumoto?
No, so he can, since the order is passed by Deputy Commissioner.
You have to file, you have to go before him. I will give you liberty.
Yes, Lordship.
Appropriate authority is respondent number, Senior Joint Commissioner.
Joint Commission.
He is the appellate authority.
Joint Commission.
Okay.
Hello.
And what you have submitted?
Doctor, this is the motivation, this exact details procedure to be followed. That is in the act also. From starting from 67, 68. Whom notice to issue, whom the authorized person, and what are the.
That notification also I handed over to your Lordship. This is the same notification.
This is this writ petition filed by the writ petitioner. Writ petitioners. Who are the petitioners? You and?
We are the owner of the harvesting machine, both. One petitioner is owner of 2 harvesting machine. Second one is 1 harvesting machine.
Say affidavit of service taken on record. Naam diye devo inarte hain. Filed by writ petitioner against the order passed by the
Deputy Commissioner.
Order passed by Deputy Commissioner.
June 20.
Page number 61.
67, no, 67A. Order 103.
No, not this order. Another order which was given total calculation and.
That is in the page number 67, the order, 28 June.
Annexure P6 is the order, Lordship. This is the type, Annexure P6, page 53 onwards, and type copy of the order is 67A to last. Type copy is Lordship 67L.
Order dated 28/6/2023, passed by Deputy Commissioner of Revenue, Bureau of Investigation, North Bengal, Alipurduar Zone. Thereby, the authority directed to pay a sum of rupees 5 lakhs,
5,08,000, Lordship.
5,08,508 in connection with goods vehicle bearing registration number GJ15AV 4728 was intercepted at Torsa Bridge, NS 31C on 9/6/2023 at about 12:01 PM during routine wayside duty by the official of Bureau of Investigation, North Bengal, Alipur Dwar Zone, Alipur Dwar. At the time of interception, we will, including other details of delivery challan and reason for transportations, was submitted. The department also recorded a statement of the driver. And finally, it is found by the authority that the goods and conveyance used for movement of the goods were detained under subsection 3 of section 68 of WBGST Act 2017.
2017.
And section 1 of section 129 of the WBGST Act 2017 read with section 3 of section 68 of CGST Act 2017. And thereby issuing an order of detention in form GST MOV-06 on 21/6/2023. Thereafter, the owner of the goods, Sri Vishwanath Devnath, has made a payment of such tax, including penalty, of the aforesaid amount of rupees 20 for release of the goods which was detained by the authority. In view of section 129(1)(a) of the West Bengal GST Act. West Bengal or
GST, state GST.
A. Police stop. Against that order, no, it is the contention of the petitioner that no notice was served upon him, neither opportunity was given to him to give reply. So authorities has violated the principle of natural justice and imposed tax as well as penalty. Who he further submits, due to the goods he has paid the said claim amount, but he is feeling aggrieved with the said order and came before this court with a prayer that the respondent shall immediately return the impugned amount which was deposited by the owner of the vehicle as a penalty for rupees 5,08,508.
Lordship, I may pardon. Lordship, the owner of the, not owner of the vehicle.
Owner of the goods, sorry.
Lordship.
Owner of the goods. In terms of payment receipt oblique challan being part of annexure P6 dated 19/7/2023.
Page 65, 66. Annexure P6, Lordship.
He does not press other reliefs
Other reliefs.
before this court. On the other hand, learned advocate, Mr. So-and-so, appear for the respondent submits that in view of provision laid down in section 129 1A of the Central Goods and Service Tax Act, West Bengal.
State goods.
West Bengal Goods and Service Act, Tax Act 2070, the owner came forward and claimed the goods are belongs to the writ petitioner. And accordingly, he paid the imposed tax as well as penalty under the provision of the West Bengal Goods and Service Tax Act 2017. If he agreed with the said order, then there is a provision to file appeal or revision.
Lordship.
Only appeal. Appeal.
Lordship, both appeal or revision, because revision provision is there also. Lordship may kindly consider this as well.
Revision is not there because you have challenged the order and you have paid. So revision would not lie on that ground.
Lordship, if I challenge the order, then my prayer be also be there. Also be there.
You want only return.
Only return.
So appeal. If you succeed in appeal, you will get return, otherwise not. What you have written? There is a provision of appeal before the appropriate authority. Under section 107 of the West Bengal Goods and Service Act 2007. This court has no jurisdiction to interfere with the order passed by the authority. Accordingly, he may approach before the appropriate authority. There is no merit in the writ petition. That's it. Under the above, having heard the submission of the both sides and on perusal of the record, I find the petitioners have come forward and paid the tax as well as penalty imposed upon him under section 129 1A.
129(3).
129(3). First under section 193. Negative 3. So he may approach before the appellate authority for his grievances. If he is satisfied the appellate authority, then his prayer may be allowed by the authority. Liberty is given to the petitioner to approach before the appropriate authority accordance with law. With all his grievances.
Lordship.
That's it. The petition is thus disposed of. With above observations.
Grateful. Sure.
My lord will be taking up 2 p.m. matters, my lord.
Yes. Yes. Possible to hear.
Passport matter. Underwriting motion, serial number 2. Passport matter, serial number 2.
Lordship, item number 2, size with senior counsel.
So not today.
Kindly give it short pass.
How many times I will allow short passover? I have already fixed 2 PM on many matters. Not today, tomorrow you do it. Next. Not today.
5, my lord, I appear for the private respondent, respondent number 5. 4, my lord, respondent number 4.
My lord, I am appearing for the Kuch Bihar municipality, respondent number 2 and 3.
What is the matter about?
My lord, this is the matter, my lord. My lord, I am appearing for the respondent number 2 and 3, Kuch Bihar.
Who is petitioner?
My lord, he is for the private respondent.
I am for the private respondent. Petitioner is not there, my lord.
Present, my lord. My lord, in morning he was not present. Now, my lord, he was not present, and this is a frivolous application. My lord,
Completely frivolous. I agree, my lord.
completely civil in nature. 2 persons, my lord, the petitioner's claim is, my lord, the private respondent has encroached his land and, my lord, constructed a khatal. But, my lord, I being the municipal authority, my lord, I have been instructed to that effect.
One person, madam.
Yes, my lord, I have brought the report. This is the report of the minister.
In spite of fixing this matter on the prayer of at 2 PM. On the
And my lord,
instance of petitioner.
Yes, my lord, yesterday the matter was taken up, then my lord, the learned
In the
advocate.
morning, who mentioned this
No,
matter?
morning it was there in the list as item number 5.
Whether he was present?
We all respondents are
Petitioner
present.
was
The
not
petitioner
present.
was not present, so
Okay,
your lordship.
begin, sir. Next category.
my lord will kindly dismiss it for default, my lord.
No.
Or my lord, can it?
None appear on behalf of the petitioner in spite of second call.
Yes, your lordship.
নাম দিয়ে দেবেন learned advocate appearing on behalf of the so and so appearance গুলো দিয়ে দেবেন are present are represented করে দিন এখন পুরো all should be mentioned in the order. For end of justice, case is adjourned for the day and fixed tomorrow.
As a last chance, my lord, kindly marks it as a last chance. Yesterday also petitioner took adjournment, my lord.
Last chance.
Grateful, my lord.
My lord, the report, my lord, tomorrow I will submit, my lord, in that.
আচ্ছা status report submitted by the kept with the report.
Be kept in the record, lordship.
আজকে দিন
My lord, a copy of the report may be kindly given to us, my lord.
I am serving to his junior, my lord.
You serve the copy to the other side.
Yes, my lord, I am serving to his junior.
Grateful, my lord.
Grateful, your lordship.
Next.
14,
Not today.
15,
Not today.
Lordship, service has not been affected yet. So fix the matter for next week. 15.
On the prayer of learned advocate appearing on behalf of the petitioner, case is adjourned as the affidavit of service has not yet been affected upon the respondent. Let the matter listed on 18th.
I'm appealing for the respondent, my lord. Matter.
Shah, my lord, he is appearing in this matter, my lord, he is on leg before court number 2, my lord, can it be fixed tomorrow, lordship?
Not today.
Not today, my lord, grateful, man.
nothing,
Same.
Under case, senior number 36.
My lord, I beg to appear on behalf of the appellant, my lord.
Who is other side?
Mr. Borgun is on the other side, my lord. It's a very short appeal, my lord. Only 1 point. I have already prepared the suggested order and assessment of compensation. So only point is, my lord, already award has been passed by the learned tribunal. And for the enhancement of the award, this appeal has been prepared by the instant appellant, my lord.
Paper book prepared.
Yes, my lord.
You have solved the copy.
Yes, I have already solved the copy.
So.
My lord, paper book is lying in the record, my lord.
Paper book আছে? You filed 2 copies.
Already filed.
Before the court, 2 copies. Liberty to file paper book before this court. ডিপার্টমেন্টে করবেন এখানে করবেন
But only point is, actually, in the present that one non-born guy who succumbed to injuries, my lord, on 7/5/2016. So he was the driver of the pickup, my lord. And 2 vehicles were involved. Another vehicle was passed.
Driver, businessman.
So on the coming from the opposite direction, one car having a registration number W32181 dashed down the vehicle of the distance, and as a result of which the distance sustained injuries and succumbed. So in the instant action, the only point is that the distance was having an income tax account, but he was a businessman, and in support of his income, he already filed the ITR, income tax return, for the assessment year. For the assessment year 2016, 15 and 16. And subsequently, during the course of hearing, my lord, for the learned tribunal, one trade license has also been filed in support of the nature of the business. And also PAN card they have also filed. So page number, the paper to page number 61, 63, the paper. So in this occasion, in this matter, while my wife, learned tribunal was calculating the just compensation, my lord, despite the fact that income has been proved by the competent authority, that is the people, the income tax department was summoned from the side of the petitioner to the land court below. And on the strength of the summons, one person, one income tax officer, came before the learned tribunal and proved the document. And that has been executed. PW3. PW. Although Following the law, formal. Income tax inspector. Page number 19. Page 96. 90. Where you go, madam? I'm posted at income tax inspector, income tax office, and someone today. Page number 19 of my paper. I am summoned today and authorized to depose by one income tax officer, namely KUMAR. I am summoned to read the report relating to the person, namely Nandan Rai. Return was filed by him for the academic year 2015 and 16, and financial year 2014. The income source, which is 2,61,600. The return was filed on 31st March 2016. Let's go to March as 19 import payment activity my lord. 7/5/2016. 7/5/2016. You have
Assessment year.
31st March. No. I've started business. Deadline is 63, my brother. 63 day number. Then you have started with then you are the income tax. Right, my brother, coming. One year income is actually, I had no idea that how you made me with an accident and I would die.
No, that is.
My lord, I have obtained after obtaining the trade license. I started my business. Yeah, I have obtained the trade license in the year 2016.
3rd March.
3rd March 2016. 16. And after first time, I had no idea that I would be with an accident. And after my demise, all these questions are being raised. So even Lorry Tribunal also assessed it. Lorry Tribunal actually only, but actually Lorry Tribunal, while calculating the just compensation, calculated the income 12,000 per month instead of 21,803. That is why, despite the fact that I give you
Income.
That is the only point.
That has been allowed.
General payment has been
Interest has already been allowed.
Interest has been allowed. I have no financial taken into account. Only point is
Yes.
because afterwards, so I had no opportunity to find the no, actually,
Only that return has been filed.
it was non-tax filed. Actually, non-taxable limit.
Non-taxable limit. Business was fruits and grocery business. And it reflects from the exhibit. Exhibit কতটা? Exhibit 18. Page number 63. Pardon.
Sufficient to accept the income.
So, my lord, to that, in that regard, my lord, I have to just a little bit research I have to make. Kindly keep it tomorrow. I'll come back with if there is any.
Very exhausted.
Day after tomorrow. Day after. I'll come back with the if there is any. I have to do little bit research on this. Kindly keep it day after tomorrow. I'll come back with the if there is any.
Lost.
Thursday? My lord, Thursday. Grateful, my lord. Simple issue, my lord.
I am there.
My lord, my lord. Next. Next matter, my lord. Item number 37. Wait. Both sides.
Lordship, I am for the respondent number 1.
Actually dispensed to his service has been dispensed to his since the owner has not contested before the learned tribunal.
37.
My lord. Well, only 3 points, 2 or 3 matters, but my first point is monthly income of the deceased. Deceased was having a notional. Yes, my lord. Yes, my lord. 2 copies. Already handed over to the lawyer of the insurance company.
Lordship, as per my seniors knowledge, I have no information regarding this paper book.
I'm again ready. I'm handing over, no issue. I have a.
Oh, okay.
Now you have to take it now. You hold it. 37.
Lordship, may I have your permission to submit 8 important points regarding this matter? Okay.
My lord, only 3 points, my lord. First of all, monthly income of the deceased has been assessed as rupees 3,300 as notional income, whereas we have paid for rupees 10,000. Number 2, future prospect has not been granted. 2020.
What is the date of accident?
Date of accident, my lord. Date of accident 11/1/2020. 2020. Regarding the notional income has been taken into consideration as 3,300. Another point is future prospect has not been granted in view of the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty. Number 3, 171 of the Motor Vehicles Act has not been complied. That is, no interest has been awarded in favor of the petitioner. No interest. Nothing has been explained. Income at all. So, in with regard to the income, already exhibit. Actually, this death case, deceased was having the business of 166. Deceased Rajkumar Chaudhary was having the business of buying live poultry birds. And on the date of accident, actually, he was proceeding towards the market for buying the live poultry birds. So we have already filed challans in order to substantiate our claim. So we have already filed challans of the poultry birds. Page number 58 and 59. 58, 59. Page number 58 and 59. No, poultry birds, that document challan has been marked. Only challan has been marked. So in support of my claim, even in the petitioner, examination chief, everywhere, the petitioner claimed that he was having the business and he was running the, even his friend also has been examined as PW2. No, we had no driving license. No, my lord. Absolutely, we had no other document, only challans. Honestly submitting and when not in the name of Rajkumar Chaudhary kind. My lord, these challans have been issued by Boshundara. Actually, he was having the farm under the name and style Boshundara Poultry. No, no, my lord. In the lower court, it was not called for. But nowadays, even yes, I am relying on that particular document. But my lord, so it is fact that we have absolutely failed to prove the income of the deceased, apart from the fact that we have produced some challans and which have been marked collectively. Besides this, we have no other documents to prove. Now, oral evidence. My lord, nowadays, the practice is, my lord, even in view of the judgment passed by our Honorable Division Bench, comprising Justice Tandon and Hiranmoy Bhattacharya. Even nowadays, even an unskilled laborer earns rupees 300 per day. So 9,000 per day is a normal. So this has been observed by our court. This has been observed by our court, and I am just relying upon the decision passed by the Division Bench, and also single bench. There is a decision about decision of the Honorable Justice Patnaik's decision. So this is page number 9,000 per 300 per day. Now it is even an unskilled laborer. This is the observation passed by the Justice Tandon and Hiranmoy Bhattacharya. And in this case, he was a quack doctor. In this case, the case in hand we have, actually we are referring, in that particular case, the deceased was a quack doctor. He did not have any driving trade license. He did not have any income tax file. Nothing he was having that. In that case, Justice Tandon held that nowadays, even an unskilled laborer earns rupees 300. Paragraph number 13, relevant paragraph number. Judgment, the Mahmoud judgment. This was observed in the year 2019, my lord. And this person died in the year 2020. My lord? No. Quack doctor. Quack doctor. Quack doctor. In villages, normally we see na quack doctors. Another judgment I am referring, this is the decision, this is the judgment which has been passed by the Honorable Supreme Court in the year 2023. The judgment, in the judgment, para number 13, in this case, the deceased was a housewife and a homemaker. So interestingly, Honorable Supreme Court observed that at the first instance, the MSCT, taking into consideration of all aspects, had awarded the compensation of rupees 6,46,050 rupees, which was thereafter enhanced by High Court rupees 7,58,150. The MSCT, to arrive at such compensation, had reckoned the notional income at rupees 3,000 per month, which had been enhanced by the High Court to rupees 4,000. In that regard, we note that the accident being on the year 2008. In the year 2008, and if, my lord, I have gone through that judgment, my lord. I've gone through. So, and even in respect of unskilled worker, if a sum of 2,200 per day could be reasonable, we see no reason why the same should not be adopted in respect of a homemaker. In that view, we find it appropriate to reckon the income in the present facts at rupees 6,000 per month. No, but even a homemaker in the year 2008, 200 rupees per day is. But I have gone through, my lord, I have gone through your judgment, and it was meticulously, it was observed by your lordship that what is the role of the homemaker and how they are playing the very crucial role in day-to-day life. They are bringing up their children and all, so rendering service towards the family. So, my lord, I have gone through your judgment. My lord, it is standing as good as. So this is the judgment I am also relying upon. This is the judgment passed in the case of Muhammad. 6,000 in the year 2008. This person died in the year 2022. My lord.
Lordship, may I have your permission to submit my
and
points? I led by Mr. Partho Bhomik, who is the impaneled lawyer from insurance company. Respondent number 1.
I interrupt, my lord, 2 points more. The future postponement has not been granted. And my lord. And interest has not been. Appealing number for the petitioner, for the appellant.
Lordship, this is the case of 2023. Principal awarded amount has been passed by the learned lower court and it has been paid already. There is a pay and recovery order, and for this reason, execution case yet to be filed before the learned court, lower learned court.
Already been paid.
Already paid. Lordship, already paid.
We acknowledge that.
It is an appeal for the enhancement. In the trial court, my senior counsel, Mr. Partho Bhomik, was not conducting advocate for that case in the lower court. Lordship, most important thing is that the 2 vehicles were involved in the alleged accident and the award has been given only one insurance company. Respondent number 1, Shriram General Insurance Company, only one.
Tribunal rightly observed, my lord, because actually this vehicle dashed at the backside of the another vehicle. Yes. No composite negligence. Absolutely, a trial court has a trial court. The finding of the trial court is that actually due to the rash and negligent driving of the driver of this particular vehicle, the accident occurred. So and that has been observed. No.
Lordship,
and this question was never raised before the learned tribunal.
Lordship, we shall file a counter appeal before this court.
No, they have
filed a counter appeal before this learned court.
At the time of hearing
the point is 2 vehicles were involved in this case, but only one insurance company, Shriram. We will file this counter appeal. We will file. So that's why we did not receive any relevant documents from insurance company till today. We did not receive any relevant documents. So we need. So Lordship, I am respondent number 1, Shriram General Insurance Company. Its legal matter is controlled from Kolkata, that is regional office, and Joypur, that is head office. So time is required for file the counter appeal. We need some time because we did not receive any relevant documents. How can we prepare our defense?
In the last circuit, they have taken the same plea, my lord. In the last circuit, they have taken the same plea. In each and every circuit, they are just bypassing.
Lordship, another thing is New India Assurance Company Limited and other 2 vehicle owners were also respondent in this case, but they did not appear before this court, yet to be appeared in this appeal, yet to be appeared. So, Lordship, kindly appreciate my submission and note it down in the order sheet. My
3 months back, they have received the notice 3 months back. 3 months back. This is the evidence of service. 87.
Actually, at that time it was told that actually at the time of hearing it is fine, just take it back. So at that time I took it back.
Lordship, one another things on the last occasion, last circuit bench, Honorable Justice Kaushik Chandra directed them to file memorandum of appeal. Have they filed memorandum of appeal? But we have no knowledge.
Yeah. On the
But Lordship, we want to file. Lordship, we want to file counter appeal regarding this case. We want to file. Lordship, kindly appreciate my submission. Please allow me. Lordship, kindly fix this matter after Puja vacation. After Puja vacation, Lordship. Okay, Lordship, at least. Yes, okay, grateful, Lordship, grateful.
On Passover matter, item number 2. It is not today. Maybe it is fixed on Monday. I will come. Nobody appeared on behalf of the respondents. Appeared. I will inform accordingly. Please, I'm requesting just to accommodate it. Then in that case, tomorrow I have to come all along from Jalpaiguri.
Lordship, Lordship.
I think that was item number 2. Serial number 2 is not today.
Okay, fine. Lordship, kindly give us at least 1 week. At least 1 week, Lordship. Kindly appreciate my submission. At least 1 week. Lordship, as a junior advocate, I have no knowledge regarding this. I have no knowledge. Lordship, my senior. But there is no reflection in the order sheet, Lordship. There is no reflection.
Along sized order. Justice Chandra was directed to start the copy. And I will tell all the copy and prepared and all.
But there is no reflection in the order sheet, Lordship. My senior. Lordship, on a good faith, it may be received from my senior, but it is as per his submission. As per his submission, I accept this. Okay, but I have no knowledge regarding this. I have no knowledge. But Lordship, from my but from the side of insurance company, we did not receive any appointment, any relevant documents.
On the other thing, senior appeared and they have to take inspection and come back.
Lordship, at least give us one chance for prepare our defense, Lordship. We didn't. Lordship, next week, kindly fix. Okay. Grateful, Lordship.
My lord, in this matter, my lord. Note My lord, cannot. Metro service has not been completed, my lord. So, my lord, I have one innocuous prayer, my lord, before lordship, that actually before the tribunal, my lord, owner has not contested, my lord. Owner has not contested, an order has been passed ex parte, my lord, and there is a reflection in the judgment, my lord. If your lordship kindly, no, my lord, I have not served. Service has not. There is, I just kindly see the order, my lord. 26/9/23. Okay, my lord. Upon the respondents, my lord. Service is the direction is there. My lord. My lord. My lord. My lord, kindly keep it in the next week, my lord. Oh, insurance situated or insurance company office situated here. My lord, kindly keep the next week. Office is situated here, my lord. Kindly. 18th, my lord. 17th. Grateful, my lord. 17th. Yeah.
29.
But no, this is the first time appearing, my lord. Let there be direction to serve the copy upon the respondent number 1, my lord, insurance company, my lord. Because since OP number 1, my lord. No interest has been granted. No interest has been granted. And as per salary certificate, actual gross income of the deceased was 25,350, but tribunal wrongfully deducted rupees 1,050 as house rent allowance, which is not permissible under law. In view of the judgment passed by the Honorable Supreme Court in the case of Indira Srivastava versus National Insurance Company Limited. This is not permissible. Only professional tax will be deducted from the gross salary. And income tax. And income. Only tax. Only tax will be deducted. And another point is multiply. Multiply has not been rightly taken into consideration. It will be 17 instead of deducted.
Only
House rent has been deducted.
of rupees 1,050.
Rupees 1,050. Tribunal. But in view of the judgment passed by the Honorable Supreme Court, this cannot be deducted.
No interest.
Multiply. Another point is multiply has not rightly been adopted. It will be 17 instead of 16. And no interest. My lord. My lord. I have also prepared the paper book, my lord. My lord, I will serve the copy because let there be direction because this is the first time it's appearing this matter. No, my lord. Let there be direction to serve the copy upon the insurer only. Insurer. Within time. Next year. Upon the insurance company. Only respondent, insurance company, my lord. Since they have not contested with the court below. Grateful, my lord. My lord. Order director बोल दे. Hello, let there be any direction to prepare the paper book. My lord. My lord. My lord, grateful. So let there be direction to call for. My lord, without LCR or paper book, it will be possible, my lord. My lord, grateful. My, yes, my lord. Yes. Only law point, my lord. Only law point. My lord. My lord. Next week, 18. My lord.
40.
But similar direction may be passed. This is the first time it's appearing down. Huh? Within time. 6 days. Stamp. My lord. My lord. My lord. Grateful, my lord. Grateful, my lord.
No. I am, Lord. I told your lordship that if your lordship needs any assistance on that matter, my lord, so I was waiting, my lord. Since your lordship is rising, kindly allow me to leave, my lord. That medical admission matter, my lord. Because the yes, that is why I am here, my lord. I cannot opt for. I cannot opt for. Lord, I will. Lord, central quota, state quota. I appeared in state JE, WB JE. So I have appeared from West Bengal, so I can get seat from central quota and state quota. Because in the medical colleges, there are state quota, central quota, and in private medical colleges, management quota is in addition. So, Lord, since I appeared from West Bengal, either I'll be admitted in state quota or central. And Lord, the classes have started from first. If Lord, if I could, Lord, we could go and join, Lord, if my Lord so pleases. I'm grateful to Lord.